Good evening, everybody. Hello. Happy Sunday night. Yes, for once I was late. I'm sure you get to rub it all in, have your fun. Oh well, time will go on. Oh, who's messaging me in Discord? What the heck is. Well. So, what the hell am I looking for here? Anyways, guys, yes, welcome. We've got some interesting stuff. So, Alec Baldwin filed a 60-page motion to dismiss. And there's a lot to it. It's not just him saying, wah, 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 this is unfair. I don't like this. Boo hoo hoo, boo hoo hoo, boo hoo hoo, him and crying and screaming. No, there's actually a lot to this. Uh, that's actually, there's a lot of there. It's not as simple, like I said, it's not as simple as him just bitching and moaning and hoping, the judge, like he screams and cries and goes, are you buying it? No, his attorneys have it put together a very effective motion. Do I think it's ultimately going to carry the day? Probably not. But it's definitely going to cause some problems for the state. And there's going to be a lot of awkwardness for the state because I don't think they've got a lot of answers for what happened here and what occurred. So we'll see what that entails. And before I get too far with that, who got first tonight? Nico got first. Good. Hey Nico, I need to send you an email. Um, if you could, or shoot me an email. We need to talk about that thing you did because I think we're all set, and I want to make sure we're set on both ends for that. And then, you guys are. Oh yeah, final. Oh, March Madness. Their selection days today for men and women, or just men. Not a big basketball guy myself. So underdogs won their conference tournaments. Yeah, I don't really. Yeah. I mean, Patrick Tomlinson, that hurts. That hurts. That's really the down. That's really the thing there. Oh, so let's go. This will be interesting. It is very interesting. It is very interesting. Um, Sandra's saying, looking forward to watching the F1 lawsuit coverage with you. When are you planning on covering it? I'm hoping I can get a copy of it soon. I mean, that's the biggest thing is I don't have a copy of the lawsuit, and I'm trying to find it. And it's been very hard for me to find. So I know there's I've reached out to I've sent emails out like, hey, trying to find copies, but I have not found a copy of the lawsuit yet. So I'm hoping to do it this week. And Aussie says, peekaboo. Hey, Hayden, how you doing? So, fucking Chrissy says, is it going to be the same prosecutor as Hannah's? Yes. Same prosecutor, same judge. Nothing changes in that regard. So, that's not. That's a good question. But yeah, it's the exact same people. It's going to use the exact same witnesses. There is no change to that. So, yes, watching Carrie Morrissey cross-examine Alec Baldwin on the stand will be hilarious. Especially now we know they're both kind of assholes, so watching two assholes collide is going to be something to behold. Also, guys, Rumble should be working now, so hope everybody in Rumble, hi. I know we were a minute or two late there. But let's get started. We're a couple minutes in. We got a nice crowd here. We'll get started. So, why did that not? Yes. Okay. So this is filed March 14th, which would have been on Thursday. and we'll get started. I hate every time you come away from these, you have to reset the things. So Alexander Ray Baldwin III. If you guys didn't know, that's Alec Baldwin's name. That really is. Judge Mary Marlowe Sommer. That's the same judge as before. So the motion to dismiss. And you guys notice there are attorneys here, and they aren't normally what you'd think because, well, Jason Bowles is a New Mexico attorney. Heather LeBlanc is a New Mexico attorney. Quinn Emanuel, Urquhart, and Sullivan, they are out of New York City. They're on Madison Avenue. But they're all admitted pro hoc vice. And then another one, Sarah Clark. I think she's tied to the company itself, the film company. Because that's just a weird that she would be brought in out of nowhere. It sounds like she's out of their offices down there. But she's admitted pro hoc vice. So he's got a whole team of attorneys ready to go for him. And they filed a motion to dismiss. Now, here's the entire... The way they're doing this is there's kind of like a history. The factual background is what happens. This is a lot. This is a lot of things, guys. And they're making allegations the grand jury process was manipulated, and New Mexico offers things differently than a lot of states. And we'll get to why that's a problem, potentially. Table of authorities, these are all the cases they cite. So you see Barrett v. State. And when you see this right here, it says the page number. Passim means it's located throughout. Generally, when you have at least 3 or more times it's in somewhere, you're going to be using it all the time. And it looks like they use it all the time. They aren't going to list every page it's on. It's easier to say it's throughout the filing. There's another one that's Pessim. They use a couple of them where they just use them ad nauseum. Then they talk about the New Mexico statutes, and that's another part of your table of authorities. And then also other authorities. This is interesting. They are citing something by Alan Dershowitz. They're talking about different news articles. They're also doing one about an Albuquerque police officer being acquitted. This is just more and more and more. And this is high quality defense work. These guys aren't cheap. They charge a lot by the hour, but Alec Baldwin's getting his money's worth. Because this is not something Bowles would have put together. Hannah Reid's attorney would not have done this. This is not something they would have done. Also, a couple of YouTube videos. So, it's interesting they didn't leave the link so you could click them. But, no, well. And they go through the preliminary statement. And I have heard this quote by Thomas Jefferson, that trial by jury is the only anchor ever yet imagined by man by which government can be held to the principles of its constitution. And it's true. The grand jury is our system's foundation for the protection of individual rights. And that's true. Their argument is that they obtained the indictment against him by circumventing the protections. Over and over and over again. Which I love how I love the dramatization of that. I think that's very brilliantly written. Over and over and over again. So, they point out that they only learned about the case the first time when the Wall Street Journal called them and said that for the first time Baldwin was being indicted. And then immediately after, the prosecutors announced it. The state's approach came by surprise. Well, It's not a surprise. I mean, they don't have to do it the way that they talked about. The state, though, apparently did promise Baldwin well in advance of making the decision. It also posted on Facebook the day before it'd be making a somber and respectful announcement of its charging decision without making public appearances. It broke those promises. Okay. Now, I understand their ultimate argument is here, we're setting the stage for the state being a bunch of assholes, so this is where it starts. The unethical disparagement was a sign of things to come. The state violated the ex post facto clauses of the U.S. and New Mexico constitutions by charging him with a firearm enhancement that had not been enacted when the accident occurred. Yeah, and you know what, though? That is to argue, like, okay, yeah, they screw up their government work. Like, prosecutors screw up. Like, that happens. The district attorney, Carrie Carmack Altwies, appointed a special prosecutor, Andrea Reeb, to pursue Baldwin, even though she was simultaneously running for a seat in the New Mexico legislature. Reeb told the DA in a private email that she wanted the DA to announce her involvement in the prosecution because it would help her election campaign. Writing lol at the idea of minting her political career in the Republican Party by knocking down Alec Baldwin, which it sure as hell would knock down Alec Baldwin. That would make you a god. You would be the toast of the town. Cedar says it's a bad cough I have. Yeah, I mean, we've been going back and forth with the temperature here, and this happens a lot. So, I need some tea. I'll probably have some tea tonight. I don't know what the deal was. I spent all day today doing a trial stream. We didn't have a problem. So, very weird. Very weird. We got through 8 hours of that and nothing happened. So, that, I don't get it. I don't get it, chat. I don't get it. We went all day, no problems, and then all of a sudden we're having problems. So, we'll just keep going. I promise we'll be all right. Valhalla, how you doing? Hope you're doing well. It's all that mustard you ate. Funny. So, let's keep going. So, when Baldwin filed motions challenging the state's unconstitutional conduct, the state withered. They did. They chickened out. The DA dismissed the firearm enhancement, and the special prosecutor resigned. Publicly, however, the state disparaged Baldwin and his counsel to divert attention from their misconduct and elementary legal mistakes, calling Baldwin's counsel fancy big city lawyers. Which, you know what, though? Compared to Jason Bowles, the fancy big city lawyers have been doing the fucking job. They've been putting in the fucking work. Alec Baldwin's paid them a king's ransom, and they've been delivering. So, these big city lawyers caught the DA with their pants down. The world was appalled. I don't know if I would say appalled. I was disappointed. But appalled? No. Was that unethical? Yeah. Was it a constitutional violation? Like, okay, you fix it and it's fucking fixed. That's not a problem. Prominent judges, attorneys, and scholars uniformly criticized the merits of the state's case against Baldwin. Yeah, some did. And I will say, Eugene Volk, he runs the Volk conspiracy. He's actually a very, this guy's a crazy dude. He went to, graduated from, UCLA at, 16. And then went to law school, at 17. Has worked for big law firms. Is now a professor at UCLA. Dude is fucking amazingly smart. Very base. He's very, conservative libertarian. Very pro-Second Amendment. He actually ran a website called The Volk Conspiracy, which is a bunch of, libertarian and right-leaning legal scholars. And it's now run by, it's on Reason now, Reason.com. but it's really good. He's really good to listen to. He's very, very, very good. Very, very good. I highly recommend him if you ever get the chance. You will not be disappointed if you read his stuff. Hold on here. Let me bring that up. So this is the thing. Oh, I turned my camera off, didn't I? This is the website that I'm talking about. Here, hold on. No. Damn it. There you go. It's on Reason's thing. It's very well done. I think it's very good. You know, they talk about like who they are. Some very good names to follow if you get the chance. Like the different professors. They have a lot of law professors writing. A lot of these guys are people you can also follow on Twitter. You know, you're generally not going to read this and have a bad time. There's quite a bit on there. They talk, you know, there's obviously a lot of legal stuff here, but then it's just, you know, it's not bad. It's not bad. Like, but the economics of Star Trek and they talk about all kinds of stuff, and I recommend them if you guys ever get the chance. Like I said, they're not bad. That's a shame, says Randy Barnett and David Bernstein. Yes. Hannah's sentencing, I don't think, has been set yet. Garrett says it's still up and running. Yeah, well, he got, like, hosted by the Washington Post for a while. Then Reason bought it up. So he's kind of bounced around to find a place. So, hold on here. Volk's blog is seminal. Yes, it was. It's very important. Oh, that's a shame saying would not have gone to law school if not for... Wow. Okay. I mean, I liked it, but I remember reading it in college, and it had its own website, so it was very interesting back then. Didn't understand half the shit they were talking about, but that's... Let's see here. Yes, at 10 years old, you earned a 780 out of 800 on the math portion of the SAT. Yeah, Eugene Volokh is a fucking beast of a human being. Yes, and Alpha Fox says, yes, the dozens of conservative attorneys in the U.S., the handful of them. Yeah, so let's just keep going here, guys. That was just a slight deviation, but it's something if you guys want to good, guy's brilliant. Guy's brilliant. So... they get through all this, and they talk about it shortly after the DA bailed out, shortly after the special prosecutor bailed out, and she appointed Special Prosecutor Karen Morrissey and Jason Lewis. For a moment, things were different. Morrissey and Lewis dismissed the case against Baldwin in April, after Baldwin's counsel proved to them accurately the gun was modified, and the state had overlooked dozens of legal issues and facts. The summer passed without event. Then in October, more than 2 years... Statute of limitations, guys, doesn't matter. Still in statute of limitations. Cry and mauled and cope and seethe. That's still, it's legal. After the accident, 6 months after Baldwin thought this wrongful prosecution was behind him, I don't know if I'd call it wrongful. It might not be the best. The case came back again. Morrissey announced her intention to present the case against Baldwin to a grand jury, as well as the November 16th date of this presentation. In an interview with the New York Times, she made false statements about the evidence and Baldwin's guilt. What are the false statements? That he's a good boy? Yes, and actually, Alec Baldwin's a very nice man. A few weeks later, she served a target notice on Baldwin, from which she removed the 48-hour deadline for the submission of Baldwin's grand jury alert letter to shorten Baldwin's time to prepare the letter. Now, what is this part? In New Mexico, the way it works, You are given notice that you are going to be presented to the grand jury. You're given an alert letter. You have a 48-hour right, within the 48 hours, to send to the prosecutor and the judge overseeing the grand jury basically an entire letter. It's not you coming in to argue the evidence, but you lay out basically in a letter form as a motion. Here's all the evidence that hasn't been consulted. Here's all the exculpatory evidence. And I demand all this evidence be presented to the grand jury because the prosecutor has it. And from there, you have a right to have your exculpatory evidence presented to the grand jury. Now, some of you are saying, wow, this sounds crazy and weird. Well, it is weird because there's only like 4 other states that do it. Nobody else does. So it's very important. It's a very important thing that Alec Baldwin did not apparently get the procedural right to do. So Morrissey admitted to Baldwin that she had never seen this deadline removed. And yes, they apparently have removing the deadline. I'm not sure about the legality of that. I think they touch on this in here. But then she stated logically she just wanted to ensure Baldwin was being treated like everyone else. In fact, Morrissey had served a target notice on Hannah Gutierrez-Reed the same day that included the 48-hour deadline. Morrissey removed from Baldwin's notice. At the same time, Morrissey was attempting to tilt that playing field. She also made the unprecedented request to unilaterally voir dire the grand jury. I mean, normally they do a basic voir dire. Normally it's the judge running a grand jury. Normally kind of like screens the grand jury. Like, it's very perfunctory. It's like 5-10 minutes long. Judge asks questions of everybody in general. So that's not a big deal there. The court denied the state's frivolous request and moved the grand jury date from November 2023 to January 2024. It also expressed concern the grand jury date and facts about the grand jury process, which hadn't been disclosed to the New York Times, for which the state was solely responsible. And that's true. The court noted the prejudicial nature of these disclosures. Oh, but there's a footnote here. We need to... Oh, yeah, they already covered that. Okay. The court noted the prejudicial nature of these disclosures. In this very case, the court explained a member of the sitting grand jury had asked the court if she could sit on the original grand jury that would hear Baldwin's case. So that's interesting, where the grand jury is like, well, can I sit on the... I can sit on the jury that would hear Baldwin's case. So they point out everybody has to shut up and not disclose anything about the grand jury process while it's ongoing. Within 1 hour, Morrissey disclosed this content to the press. Oof. Including the new grand jury date, even if the court admonished her to do that. Baldwin therefore filed a sanctions and contempt motion, which prompted Morrissey to violate the court's order a second time, because she also disclosed the contents of that motion to the press. Well, I think you could argue, well, yeah, because that all stems from an original violation of the rules talking about the grand jury. Yeah, so that probably would count. That probably would count ultimately. That's not even an actually. That's fair. Baldwin next submitted an alert letter identifying significant exculpatory and favorable witnesses and documents, as well as jury instructions on the relevant offenses and defenses. But the state refused to present nearly any of that evidence to the grand jury, supporting its position with old case law that had been overruled by the New Mexico Supreme Court and New Mexico statutory law. The state also refused to read Baldwin's proposed charging instructions to the grand jury, noting it would read a different instruction about intervening cause, even though the state's preferred instruction stated it did not apply in homicide cases, which for a manslaughter case is a homicide case, and would not read an instruction about involuntary manslaughter that deviated from the uniform jury instructions. The state therefore filed a motion seeking permission to disregard Baldwin's alert letter. The court denied the state's motion with respect to the evidence. The court ordered the state to make nearly all the favorable evidence and witnesses available to the grand jury. As for the jury instructions, the court ordered the state to provide Baldwin's requested instruction on the issue of intervening cause if the evidence supported it. And the court ruled the state's instruction about involuntary manslaughter must track the jury instructions, which it has to. Deviating from the uniform jury instructions, well, that's there's no reason to. There's no reason to. There's no reason to here. Then says the court's ruling just came days before the grand jury presentation was set to start, which, given the schedule, left only 2 days for the state to present the entire case before the grand jury's term expired. And that's the thing, the grand juries can only set for a certain amount of time by law, and you don't get to extend it. And if you run out of time, you have to pick a new grand jury, and you have to start a new session. Well, and however many, like, you might not be able to call, you can't just convene one willy-nilly, probably. Unlike Fannie did in Georgia. She did a special grand jury. This one probably wouldn't be allowed to. Baldwin warned the state in writing that it would not have enough time to present the evidence from his alert letter before the term ended, and he asked the state to adjourn the grand jury date to ensure his evidence could be presented. But the state ignored Baldwin's letter and jammed its presentation in barely more than 1 day. The state did so by violating nearly every rule of the book. It did not explain the meaning or purposes of Baldwin's letter to the jury. It did not tell jurors they had the right, and in fact, the obligation to request to hear all exculpatory evidence. And that's nice, because that's not a requirement in every state. The state did not make Baldwin's witnesses available to testify. It did not present the exculpatory and favorable evidence to the grand jury. When the jurors asked questions about the exculpatory witnesses or facts, the state instead forced them to hear answers from the state's chosen witnesses, even when those witnesses had no personal knowledge or foundation for giving the testimony. And to top it all off, the state read the grand jury an involuntary manslaughter instruction that violated the court's order. So, the state, if they have really done all this is massive misconduct by the state. State prosecutors have engaged in this conduct and publicly dragged Baldwin through the cesspool created by their improprieties. Well, ultimately, Baldwin drug himself through a pile of shit that he threw down on the road. By being himself and making this shit movie called Rust, this is what happens. So, this is entirely Alec Baldwin's fault at the end of the day, I would argue. They did this without any regard for the fact that serious charges have been hanging over his head for 2.5 years. You know, you could find a lot of poor people dealing with this, so you're not going to get a lot of sympathy there. Enough is enough. Enough is enough. This is an abuse of the system, an abuse of an innocent person. Well, I don't know about innocent, but he's presumed innocent, whose rights have been trampled on to the extreme. The court should dismiss the indictment. And they talk about dismissing it where the grand jury misconduct is so fundamentally unfair. So, the initial things that happened here. The actual beginning of what happened, we're not going to get into that here because we know the story. Baldwin fully cooperated with the state's investigation from the beginning. Yeah, except for not handing over your phone for like 6 months. So this is where we get to the stuff that I think matters here. 6 months after dismissing all charges, the state again pursued an indictment. So it's this October 5th interview to the New York Times where she improperly disclosed details about her intention to present the case to the grand jury, which is important because the grand jury is secrecy. You should be making that secret. There's leaks, that's one thing, but for her to go sit down with a reporter and say, here's what we're going to do. Can't be doing that. You can't be doing that. Oh, Flux is here. Hi, Flux. Hope you're doing well. So, where? So, the article explained the prosecutor's view that evidence about the gun contradicted Baldwin's assertion he had not pulled the trigger. And they said the forensic testing concluded the trigger of the gun had to have been pulled for the gun to go off. The article further reported that Morrissey said the prosecutors intend to begin presenting the case to a grand jury on November 16th. Raising the serious risk which came true, that sitting grand jurors would read the press, be tainted by it, and actively seek to be assigned to Baldwin's case. Well, that's how do you think homies? There's people all over that get screwed. So don't act like this isn't just unique to him. I mean, it is sad and tragic, but a lot of people getting bent over by the system. Now, they rigged the process ahead of the grand jury. That's a big statement. So they point out that after improperly announcing the grand jury date, they also served the target notice that omitted the 48-hour deadline. Although they said that they had never done that before, and they'd never seen it before. In an email from Carey to Baldwin's counsel said, every target notice I've ever seen in New Mexico has a sentence that indicates a target must notify the prosecution of potential witnesses or exhibits 48 hours prior to the grand jury date. After admitting she eliminated this thing, she said she was nonetheless happy to work with Baldwin's counsel in regard and will fully consider any request. And although Morrissey said she intended to ask the grand jury judge to shorten the deadline for Baldwin to submit an alert letter from November 14th to November 10th, just after he received the target letter, she also asked whether it was agreeable and let me know your thoughts. So, well, Baldwin said they should receive the full time to submit an alert letter. They're like, no, give us the time we're entitled to under the law. They also stated the grand jury should be adjourned to allow the state sufficient time to review the voluminous alert letter that we will be submitting, which probably was multiple pages, to ensure the process is done properly. And they said that it's to alert the grand jury to a lawful, competent, and relevant evidence that disproves or reduces a charge or accusation, or that makes an indictment unjustified, and that is within the knowledge, possession, or control of the prosecuting attorney. They point out there's a significant volume of evidence. The consequences of any failure to present exculpatory evidence are severe, and that's true. Baldwin asked Morrissey if she was willing to discuss a reasonable schedule. And that's important. You have to try to work this out ahead of time. You can't just, oh, well, I'm going to, it's unfair, and then you just walk away. You have to show you tried to go out there and fix this. That they tried to reach out and say, hey, Carey, wait, this doesn't make any sense, dude. Can we work on this? Can we fix this? Are you sure this is really what you want to do right now? Because otherwise, how do you fix stuff? And the court's going to ask, well, why didn't you fix this the right way? Why didn't you do something about this? And that's a problem. That's a problem if you don't address it. You can only say, we tried. Because if you can't say you tried, well, the court's going to look at you and say, well, is there really harm if you didn't try to fix it? And although she expressed a willingness to work with Baldwin's counsel and discuss a schedule that was agreeable, Morrissey immediately rejected the request and stated that Baldwin was not entitled to additional time to request that certain evidence be presented to the grand jury. She also claimed the state intended to treat Baldwin no differently than similarly situated defendants in New Mexico, even though she had just admitted she'd never seen a target treated that way. Well, I'm assuming they got the receipts for it, because if they do, oh God, Carey's in trouble. Carey is in trouble. And I have to sneeze real quick. Hold on, guys. Sorry about that. In fact, the special prosecutors had already treated Baldwin differently. On the same day they served the notice on Baldwin, they served the same letter on Hannah Reed. The one to Hannah Reed contained the 48-hour deadline that she had intentionally deleted from Baldwin's letter. And they've already filed this as an exhibit number 4. On October 30th, the state filed an expedited motion to shorten Baldwin's time to present exculpatory evidence by 4 days. And why? Why did they do that? That doesn't make much sense. Why did they have to do that? In the motion, the state falsely represented that it had provided Baldwin continuous access to its investigative file when the previous prosecution was dismissed, and argued that in any event, Baldwin didn't need the full statutory period to provide the evidence because he was already well aware of all possible directly exculpatory evidence today. No, that's not true. Stuff can always pop up. You never know what's there. That's why you always check everything, because you never know what you're going to find or have missed or have looked over. Beyond that, the state claims that Baldwin would intentionally withhold the requested evidence until exactly 48 hours prior to the grand jury case to cause a postponement of the grand jury proceeding. Even if that's the case, so what? If I have a 48-hour time window, I'm allowed to use that time window. Legally, if I take up all the time you've given to me or afforded to me, I can't have that held against me, because if you said I have an hour to do something, I might start at the 59th minute and finish it. Why? Well, because I'm allowed to do it that way. You never said a specific type of performance. So this stuff right here is just garbage, and the defense is rightly attacking it. So, as Baldwin explained, the state's proposition was backwards. Baldwin was entitled to submit a letter up to 40 hours before the grand jury proceeding, and all the state had to do to alleviate its self-imposed time crunch was adjourn it to another date and let the new grand jury take over. And he's right. We could have just picked another time. As Baldwin explained, the state's argument made no sense. The purported fact Baldwin had access to massive numbers of files would support him giving more time to review the documents and draft an alert letter, not less. Yeah, but it's like, what the fuck were you guys doing in the meantime? The only plausible inference to be drawn from this and what they did to Hannah was the state wanted to make it harder for Baldwin to alert the grand jury to relevant exculpatory evidence. Maybe the state, maybe Carrie Morrissey really is out to get Alec Baldwin and come after him. I mean, she doesn't like she don't like the fags, guys. She's the enemy of fag. So let's see where you guys are. Sandra's saying this is well written. It's clear and concise. It is. You get what you pay for. These guys are the best. Some of the best. Let's see here. All right, well, never mind. I'm trying to... Wow, I'm catching... I'm staying caught up with you guys. She wants to feed Baldwin Turkish delights. Yes. All right. So, in parallel with this unprecedented effort to shorten Baldwin's time to submit an alert letter, the state also made an unprecedented request to conduct a one-sided voir dire of the grand jury. The purported reason was to control for the significant amount of information, some of it inaccurate or incomplete, being made available to prospective jurors through the media. What the state's motion failed to acknowledge is that all the things in the media environment that were surrounding this were primarily a result of the state's own unethical press campaign. Or some of it was just failure to control evidence, because we learned a lot before things had even progressed. The court heard the argument regarding the state's limit to attempt Baldwin's right to submit a 48-hour letter and the state's request to voir dire the grand jury. The court denied both motions, and it sounds like that was the right idea. On November 14th, 48 hours before the grand jury was scheduled to begin, Baldwin submitted an alert letter to the state that identified several key witnesses and dozens of documents that would disprove the charges against him, or otherwise make the indictment unjustified. Specifically, the alert letter identified the following witnesses whose testimony would be exculpatory or favorable to Baldwin's case. Joel Souza, the director. We heard him testify at trial. As stated above, the director was primarily responsible for all creative aspects of the film and relied on the entire cast and crew to bring his vision to life. He was present in the church during the rehearsal scene and was struck by the fatal bullet as it went through Halyna. The letter stated Sousa's testimony would make clear that the firearm safety lies with the armor first assistant director, not the actors. Okay. And that Baldwin did not negligently act, he wasn't acting negligently on set. The alert letters included 40 non-leading questions that could have elicited exculpatory testimony from Sousa. Now, I mean, he wasn't asked necessarily anything set up likely by Alec Baldwin's attorneys, but I don't recall him setting up any softballs for Alec Baldwin or like any questions where Alec Baldwin sitting there like saying, yes, that's out there now. Dave Halls. Dave Halls is the first assistant director. And he was the guy who testified that Hannah handed Alec the gun. So, Halls is aware of the conditions on set in the day of the incident. He was present in the church. Yeah, but, we saw that guy with the fake smoke had to get it all sprayed up. The alert letter stated that the testimony would establish the responsibility for firearm safety lies with those two and not Baldwin. And that Baldwin did not act negligently on set, and that Halls admitted he was the last line of defense to protect against this accident. This letter included 53 non-leading questions that could have elicited exculpatory testimony from Halls. I don't know what they would have got out of him because based on what he did in Hannah Reid's trial, like, oh boy, this is not looking good. So I don't know what he thinks that's going to help him with here. But oh well. They have Sarah Zachary. We already heard from her that, she was given immunity, testified about what happened, and she dumped a bunch of bullets out. Well, her letter had 76 non-leading questions that could have elicited exculpatory testimony. Okay. Then Ryan Smith. He's one of the producers of the film. He talked. He was interviewed. He was given testimony. They point out that his testimony would undercut the state's producer theory of liability. And that he would also confirm that Baldwin wasn't on set or even the state in New Mexico for most of the filming was done leading up to the accident. Well, yeah, because if he's staying in somewhere in New Mexico, I'm sure he's running up a bill and is running in the best thing you could find, which is probably some sort of very, very nice trailer, which, like camper or something or whatever, but it's not going to be cheap. So yeah, it's cheaper for them to leave him out on the road till they need him in LA or New York City. His letter had 17 non-leading questions. So it'll be interesting to see what he says. Detective Alexandria Hancock. She was the lead investigator, and we heard her the whole time. She's the one who was like, she looked like she was about to fucking cry the whole time, with her 85 pounds of collagen shoved in her lips. They talk about the dozens of exculpatory statements from numerous witnesses, as well as the major gaps in her investigation. Yes, there were in the collection of evidence. She messed up bad. But they're not going to agree to it. Yeah, we learned that she was awful at it. This alert letter had 105 non-leading questions. Interesting. These guys did a lot of work putting this all together. As stated in the alert letter, Joel Cano was an investigator who was on the scene. I think he was involved in making sure the ammo trailer was secured, and then also some of those props were kept inside the tape. So it'll be interesting to see what he talks about there and how the evidence was protected and gathered. Was it unsecured? Yada, 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 yada. But here's one of the ones. This one I did not know. Robert Schilling is hired as an investigator for the state and was aware of the deficiencies in the investigation, including leads that had not been run down. He had expressed a view that the investigation conducted by the Santa Fe Sheriff's Office over the course of more than a year contained numerous critical errors that could not be remediated. Their alert letter included only 9 non-leading questions for this guy. But it's interesting, they didn't even bother putting him up there. I think it's because he did some basic searching and realized, oh my gosh, we might be the bad guys. So, yeah. In addition to these witnesses, the alert letter identified 23 documents Baldwin contained would disprove the charges against him. You know, the recording of the 911 call, which somebody says the gun goes off, described as an accident, and places the blame on someone else other than Baldwin. I think we heard about that. The warrants contain numerous exculpatory statements, which they normally don't, unless the cops aren't trying to get the warrant. You know, that Baldwin had been very careful of firearms on the set. A statement Halls told everyone the gun was safe to handle before it went off. And what makes it even worse for them, and this is Baldwin still arguing it, Hull said she should have checked all the rounds in the gun, but didn't. And Hannah Reed said she didn't really check the gun too much before giving it over to Baldwin. So, ow. The bigger thing they're going to rely on, and I think this is something Hannah Reed tried to do this with the 2 OSHA inspectors, was the New Mexico OSHA report that demonstrates Baldwin was not rust management and that his authority on set was limited to creative decisions. Yeah, but you heard him screaming when we watched the video. He's screaming like a lunatic. Screaming like a lunatic to get things done. It's just, it is mind-blowing how he treats that. He's acting like, oh, I'm not important. It's like, dude, you are a lot more important than you're willing to admit, which I think at some point is going to bite him in the ass because it's not like a jury's not going to buy he's not in charge. I mean, he's basically in charge. I don't see how that gets to him at the end of the day. Yeah, they all testified he ran the show. Yeah, I mean, that's part of it too. I don't see how he survives that. I don't. And that's, oh well, if he thinks he will, you know, good luck to you, Alec. Let's see what happens, man. Let's see what happens. I don't think it's going to go like you thought it would. So, you know, you worry about, don't yawn. It's like, I'll yawn if I want. There were text messages between Sarah Zachary, Hannah, and Seth Kenny, which contained evidence that Hannah went target shooting with the driver of the prop truck before the incident, and that unbeknownst to Alec, Hannah consistently failed to follow proper safety procedures on the set of Rust and a Philvius frame project. We already knew that. Nicolas Cage kicked her off a set. Yeah, we already knew she was dangerous. A letter signed by many of the cast and crew disputing that the set of Rust was inherently unsafe, which that's going to be interesting to see because enough people said it was unsafe. So who's right, who's wrong? I mean, I think we all know who was probably right, all the crew who left, but you know, it's not just something you can do. We have to come up with an answer for that. The transcript from Dave Hall's proffer interview in which he blames himself for the incident states no member of the cast or crew could have anticipated there would be live rounds on the firearm of the set. Probably. I don't think we've seen that interview, the full part of it, but overall it's really good. The letter also requested specific objections to the grand jury on two critical elements of the charging statute. First, Baldwin requests an instruction that the criminal negligence standard requires the prosecution to show Baldwin had subjective knowledge of an actual risk the firearm placed in his hand had been loaded with live ammo, that the gun he was handling was likely loaded with 5 rounds, and therefore posed a significant risk to human life, and that he willfully disregarded that risk when pointing the gun towards Halyna. So this is where they talk about the second part. Baldwin requested an instruction that proximate cause is an element of causation, and it is. And that the element of proximate cause is negated where the negligence of a third party was the only significant cause of death, or it constitutes an intervening cause that broke the foreseeable chain of events. So, on November 15th, the state filed an expedited motion to preclude nearly all of the documents and witnesses Baldwin had put together in their alert letter. Which I still don't know why she did this. It blows my mind. She thought this was an okay deal. Or did she have like a dumbass like assistant prosecutor working with her or something? I don't really understand how this happened the way it did. The state also sought to preclude Baldwin's requested jury instructions. We already talked about that. The state further argued that an instruction properly assumes the factual basis of negligent act was failing to check the firearm for live rounds. According to the state, whether or not Baldwin had subjective knowledge of an actual risk, the firearm placed in his hand had been loaded. With live ammunition, it has nothing to do with the other ways in which the state intends to show he negligently handled a firearm, resulting in death. The state also refused to provide Baldwin's requested causation instruction. The state stated that it intended to provide a different instruction, even though yet in another blunder, the state's preferred instruction that stated it didn't apply in homicide cases. On the 15th, the court held a hearing to discuss the party's stuff. The court said that given the length and breadth of the state's motion to preclude, the court was vacating and rescheduling the grand jury till January 18th. Okay, so we got a new one anyway. The postponed argument of the state's motions to give the court time to review the party's submissions, which is what they wanted. And that's exactly what Baldwin had asked originally. At this hearing, the court also expressed concern about the fact the grand jury date and had other information about the grand jury process that had been disclosed to the media. Oh. Sorry, guys. I lost my spot here. I just got an email here. The court also expressed a concern the grand jury had been disclosed in the media. The court explained that disclosing the grand jury date to the press, which the state did, created the risk of prejudice that grand jurors had in fact approached the clerk seeking out service on the grand jury. I'll check over that. Well, I wonder if there's a way to check that, because, like, if people did, like, how could... I mean, I don't think that should have worked, people seeking to serve in the grand jury, like, how would that work? Like, hey, put me on the grand jury. Sir, you're already on the grand jury. I know, but I want to do this one now. That's going to happen. Like, how would you get that? So do you make this allegation? That just seems stupid on its face. I mean, I can't be wrong there. That just doesn't make any sense. Young Forever's been a member for a month, says, who's got that Gorilla Grip privilege protection? Yeah, well, Alex got it, but my God, it's almost like a little too overpowered. So, holy jeez. So, and, oh, what are we doing here? Guys, give me 1 second. I'll be right back. I have to go to the bathroom. All right, guys, we're back. All right. The court therefore equivocally and unequivocally repeatedly ordered the parties to not disclose information about the grand jury or processes or what happened during the hearing. And as I talked above, within 1 hour, they were already telling everybody what happened. Baldwin therefore ordered sanctions a contempt motion, which ordered again making the disclosures. And as if things couldn't get worse, the state also revealed its illicit motivations behind its prosecution, as they reported in an article. Which I don't think we've seen all these articles, and that's part of the issue here. And that was a fast pee. Well, I didn't wash my hands. Hold on. Nah, it didn't smell like pee. I think I'm okay. The quarry pee drain. There is not a drain or a pee bottle in this room. I literally have a bathroom right outside the door and right around the corner. And if you guys are on Locals and you become a member, you can find out, because the video's up there, of the studio tour. Have a lick. Okay, fine. There. Make you feel better? Doesn't taste like pee, Luke. That was a funny thing. I knew a kid who used to do that all the time. He'd go to the bathroom and he'd come out and he'd be like, does that smell like poop to you? And he'd shove his fingers in your face. And then he'd go, one time he did this, I saw this happen, and a kid got sick. A kid started dry heaving because he went and he said, does that smell like poop to you? And the guy's like, no. And this kid I knew went like, yeah, no, that's not poop. And the guy started like run over to a garbage can and started started dry heaving for like 5 minutes. It was really, really fucking hilarious. I'm like, oh God, I wouldn't even do that. But the kid was like, ugh. He was like, ugh. Yeah, I don't think he barfed, but he was very, very much dry heaving for a second. See, I know Don Lemon. Yeah. Funny. So, and this is apparently what they're saying here, but the prosecutors haven't said publicly what new evidence had they obtained during their months of investigation, but a source familiar with the case said the prosecutors have had discussions in which they hope the trial will humble Baldwin, specifically citing his runs with the paparazzi and public comments that weren't about the case. The source added the intention is for it to be a teachable moment for Baldwin. Well, yeah, that's not what you should want in a prosecution. If he deserves to be brought to justice, bring him to justice. It's the goal of a trial is not to take someone down a peg or two. This is not like the fucking Christmas, like a Christmas story where like the ghost of Christmas past and, past, present, and future try to humble you. It's not like, oh, it's a wonderful life. No, their job is to seek justice, not to fuck with people. The following morning in today's show, the press added the special prosecutor said they were also targeting Baldwin because they think he's arrogant. Well, that doesn't matter. That's not a valid grounds to prosecute someone. That's not at all valid grounds. This was a stunning and extreme abuse of power. Yeah, they shouldn't be disclosing those. Like, why are we prosecuting him? Because he broke the law. Not because, he's a flashy, dashy asshole. Well, that's not how that works. But it became consistent with the state's motivations when Andrea Reeves said she wanted to do this so she could help her election chances. Like, we're seeing this again and again and again and again and again. The court orders the state to make virtually all of Baldwin's exculpatory material available to the grand jury. And this is where it's getting serious, guys. Like, all that shit above is bad. This is really bad. Okay? The court overruled the state's objections and held the grand jury must be told about nearly all of the evidence the state had sought to exclude. The January 11th order also rejected the state's narrow view of what it means to conduct a fair and impartial grand jury proceeding, and provide the state with a roadmap to comply with its obligations. To begin with, the court explained the state needed to facilitate the grand jury's inquiry into any lawful, relevant, and competent evidence initially not presented by the state, and cannot unilaterally withhold evidence or witnesses requested by the grand jury. Now, we mentioned this. This is Alec Baldwin getting his ass saved right here, because if there is enough exculpatory evidence, the grand jury might say, well, I guess, yeah, he didn't do it. No bill. The special prosecutors were therefore obligated to alert the grand jury to any lawful, incompetent, and relevant evidence identified that would disprove or reduce an accusation or make an indictment unjustified. The state's inaccurate assertion is that they were only required to present evidence that directly negates defendant's guilt, which isn't true. You're not going to find things that directly negate your client's guilt most of the time. It's all stuff that starts poking holes in the state's case. It's never usually something that completely dismantles it. You know, beyond reasonable doubt is not a dismantling of someone's case. It's generally just knocking enough holes in a case where it takes on too much water and sinks. So that is a... Yeah. It's just, I don't know. I don't see... Yeah. Is it lawful law? No. And then Carrie Matchett for $9.89 says, thank you, by the way, saying, this is Lofty's argument. Lofty's argument is that the Hollywood actors have special rules. Alec Baldwin's just saying, you didn't even let us play by the normal rules of Minnesota, or of New Mexico. Why did I say Minnesota? Of New Mexico. You know, that's the problem with these two. So, which adding to its legal amount, with adding to its mountain of legal errors, the state cited overruled law to support. The court confirmed Baldwin's evidence need not to be directly exculpatory to compel the state to alert the grand jury to its existence. And that's the thing. It can be out on the fringes. Exculpatory evidence can negate it in any amount. But this stuff probably likely, whatever it is they're arguing didn't get cited could, negate everything. But we'll see. So, they point out that the state laws are to give the grand jury access to more evidence, not less. And that's, yeah, why wouldn't you want that? Why would you not want that? And, we got 250 people watching here on YouTube, 3 people watching over on Twitch, and then 77 people watching on Twitter. Guys, thank you very much for being here. I appreciate it. I appreciate it. A lot. Where... Keeps jumping around on me. Applying these principles, the court ruled that all 7 of Baldwin's witnesses must be made available. Oof. The state was ordered to alert the grand jury about the witnesses and their testimony because the state failed to persuade the court that the testimony may not disprove or reduce a charge, which is fine. That person actually has to help. Or may not make an indictment unjustified. As for the documentary evidence, the court ruled in Baldwin's favor with respect that 20 out of 21 documents the state had sought to exclude. In a separate order, the court cautioned the state it must provide Baldwin's requested proximate cause instruction, even if the evidence supported its provision to the grand jury. I think they're saying that even if the evidence doesn't support its provision to the grand jury. But, we all do typos. We all do typos. Now, the court did disagree with Baldwin, though, that it was necessary that they had to prove Baldwin was subjectively aware the gun he was handling was likely loaded with live ammunition. And that's just because pointing guns at people are inherently dangerous activity. You should presume that it's loaded because if you don't and it goes off, you kill people. So this is the court accepting the state's argument is improper to require an instruction that is intentionally different from the relevant uniform jury instructions. Well, people can bitch and moan about that at a later point. This is an interesting statement, though. By adhering to the jury instructions, the uniform jury instructions, the prosecuting attorney can avoid. Sorry, I already forgot that. I forgot I had already read this part last night, and I thought it was very poignant. By doing the uniform jury instructions, you can fulfill the dual obligations of protecting the public interest and the rights of the accused. And that's the thing. Jury instructions that are pre-done, are usually done through your state Supreme Court, through multiple judges, law professors, defense attorneys, and prosecutors in these big working groups, and they come together to make the uniform jury instructions on its face that are pretty fair. Now, there might be times you have to throw in special things or remove certain things, but on its face, they could read this and the jury could figure out what's going on. And Carrie Morrissey did not do that, and that's part of her problem. She did not take advantage of this and instead did whatever the hell she wanted, it sounds like, which this is the kind of stuff that lets Alec Baldwin walk free, guys. This is that kind of stuff that Alec Baldwin might walk free on. You know, violating grand jury, like violating your right to a grand jury that apparently you have under your state law, like, there's only so many ways to remedy that. Only so many ways. Hold on. Heck. Okay, put right there. Ow. Gosh, freaking splinter in my foot. Oh, sorry, Chad. I stepped on a piece of 3D printed plastic. And I had to just pull it out. Ow. That wasn't pleasant. That stuff is sharp. Imagine that, though. Sitting here like a dumbass, just like taking pieces of this and just like slicing it off, and it falls on the ground. It's razor sharp. Like, you know, good job, Copernicus. Good job. You just figured that out. It was going to be a problem. Oh, they're giving a lot more than the old razzle dazzle. This is very effective advocacy here. I don't think you guys understand. They're convincing me. I'm not saying he's not in the clear. I'm saying that I think this was improperly indicted. If this at all pans out the way they're arguing it is, like, yeah, this is not good. This is not good. And I would rather Alec Baldwin walk than he be improperly prosecuted. So, the special prosecutors conducted a sham grand jury proceeding is a violation of the court orders, and there has to be a punishment. And I've said this before. I know courts don't like to do this, but like when when police violate the Constitution, the exclusionary rule has to apply. Court's like, well, we can't punish the cops. That's not fair. You should punish them, because then people come to meetings and say, why do you guys suck? And there's accountability that gets demanded. Well, this is a way you demand accountability. I hate to say it like this, but yeah, this is kind of fucked up. Because the state has an obligation to act in a fair and impartial manner during grand jury proceedings. But there was a different agenda. Now, remember, this is the one side. I will keep an open mind because Carrie Morrissey gets to respond. But I'm assuming, because we're on page 25, there are... I forgot, does he have any... No, he doesn't have any... Don't even have exhibits. I forgot he doesn't have exhibits on this one. So we're not going to worry about that. How long have we been going for? Just now we're making good time, chat. We're going to keep going. Where is... So, at its starting point, the state intended to proceed with the grand jury proceeding on January 18th, even though the term was set to expire on the 19th. That is kind of shitty. And there's no way the state could have presented all the relevant evidence in that time frame. Therefore, on January 18th, Baldwin sent a letter to the special prosecutors expressing their concerns about the ability to comply with their obligations. And they said, look, we've got our stuff and you're not going to have time. And they said, based on the numerous questions you asked the court about the logistics of completing the process with only 2 days, we're concerned you will be unable or unwilling to present all the information in the alert letter or may attempt to circumvent your obligation to do so. Appears that might have happened. Whoa. So, and it's Baldwin, but that's what they're referring to instead of saying the defendant. This is a nicer way of arguing it. Baldwin reiterated that the state is required to present the alert letter in its entirety and to completely present any information the grand jury wishes to hear, regardless of when the term expires, and that any effort to circumvent the obligation, including directly or implicitly encouraging the grand jury not to hear information because of prolong their term of service, would violate New Mexico law. I bet that comes into jury tampering. I think at some point you're telling a jury not to do something so you don't run into problems. Yeah, I would assume that's illegal. The letter requested that the state's presentation go before a new grand jury that has sufficient time to actually hear everything. And they reserved Baldwin's right to seek dismissal against any charges that resulted from the failure to comply with the above obligations, which they're doing now. So the state presented false and accurate testimony to the grand jury. The state presented 7 witnesses. Okay, 3 are on the district attorney's payroll, 2 are from the sheriff's office, and 1 is suing Baldwin for money. And another began blaming Baldwin in the media within days of Hutchins' death, even though he quit the production before the accident and was not on set when it occurred. Well, of the state's 7 witnesses, only one, Ross Diego, the one suing Baldwin for money, witnessed the accident. Now, Ross is the guy, the Walter White-looking dude. If you guys remember, he's the guy in the red jacket. He looked like Walter White. He's the dolly grip. I mean, he controls the camera dolly. Yeah, here's actually a picture of him. This is him if you guys don't remember. And he spoke at length, and he was very pissed. He was very pissed off. He was helping immediately, trying to help Halyna, and he was one of the few people in the church when the shooting happened. So that guy is... The dolly grip is not as good as the gorilla grip PP, yeah. Yeah, it's also Gary. The guy's also... It's a cosplay of Gary. Oh my god. He's gonna hide if you guys... Oh. You guys are funny. The Amateur Iconoclast gifted 5 memberships. Thank you. And whoever gets one of those, I know is going to be very appreciative. And I thank you for your support and your generosity. Iconoclast, thank you. So, you guys have seen him. You understand who that is. Alexandria Hancock, the detective, and Marissa Popple, a crime scene investigator, were called to testify about their investigation. The SFSO mangled nearly every aspect of the investigation. Now, here's things. Like, they bring up some things, though, that we've already addressed, and the court's already addressing, yeah, not that big a deal. The SFSL let the prop card unattended. But remember, Bowles was making the argument, so better attorneys might be able to do more. So cast and crew members were able to tamper with it. Similarly, the prop truck where the weapons were stored was left unsecured on the property for nearly a week before it was searched. And this allowed at least one crew member, Hannah Reed, to remove evidence from the truck before the search warrant was executed. Furthermore, they received reports from multiple people concerning allegations that individuals connected to the filming were firing live ammunition at the ranch on or around the day of the accident. I still can't believe that's true. This is like an old wives' tale. But given what we know, I can't imagine this really happened. If they can prove this happened, that means half the people have been lying, which I don't see that being the case. I don't see that being the case. Oh. Just because a jury may ultimately disregard it does not make it exculpatory. That's true. That's very, very true. And just because you think it's exculpatory doesn't mean a jury will think it is. So, even if it truly is exculpatory, if you think a jury might look at it. Yeah, this whole thing is just... Why is it doing that? Oh, but this is just... I don't know what to say about this case, guys. It's just... So much of this was shot down already. Like, is it going to work now that we know what happened? Well, like, yeah, I didn't have the cart in my vision the whole time, but where was your head looking? At the cart. But, we went through all of that. So some of this, I'm like... Some of this is kind of like there's arguments that go through it, but then there's arguments that, like, defeat it. Another individual reported after the incident they had heard individuals working on another film discussing how some of the people working on Rust had been shooting cans off posts. That's there was a rumor of it, but I don't think it was ever confirmed. Nobody ever touched on that. I'm assuming that they had determined that never happened. I'm thinking it never happened. It also been reported the sheriff's office as a team decided not to seek fingerprint or DNA testing of live rounds because they didn't want to identify who was bringing them there. And finally, the firearm that discharged this live round, one of the most significant, if not, the most significant piece of material evidence, was destroyed by the FBI at the direction of the SFSL but cannot be tested in the condition it was in when the accident occurred. Yeah, but it could be redone. Lucian Hag and those guys could probably rebuild it. Or they could have it sent to PA and have them rebuild it. Some of this is not going to help. Maybe I don't know. Yeah. Instead, these witnesses were guided through tightly controlled and misleading questions that supported the state's narrative against the Baldwin, the defendant. That's how the grand jury goes all the time. It's tightly controlled, and it's full of them feeding you shit as a witness. And that is meant to go against you. Like, I understand that you have these protections, but, like, what the fuck? Like, I get it. It's meant to be, like, pointing out how unjust it is. But this is how a grand jury works. This is how the grand jury works. This is 100% how the grand jury works. So, which I'm glad that maybe we're now learning, or the public's learning, like, how shitty these prosecutors are. But, for any of us that are in the know, it's like, welcome to the party, first time. Walter Malone says Lofty confirmed it happened. What the fuck did Lofty confirm happened? He didn't confirm shit. Don't tell me. Don't start with that. Lofty knows. Oh my God, don't do that. Lofty, do not give Lofty a dub. Wear Lofty W. Don't do that, chat. Do not. Don't you fucking dare do it. Don't you goddamn dare do it. Do not give Lofty a dub. Assume anything Lofty says is the exact opposite. Yes. So after Hancock and Popple, the state called Michael Haig, one of the state's purported firearms experts, to testify. Now, Lucian Haig, the dad, testified in trial. The son testified in the grand jury. One of the state's before witnesses tested the firearm would not have fired that day in the incident unless Baldwin pulled the trigger. Haig, who had no personal knowledge of the testing, which, that's not really that big a deal in the grand jury because it's not that evidentiarily tied. Because you can do a little more hearsay and stuff at the grand jury, not completely, but you're allowed to wiggle around a little bit because you don't have to call like all 40 witnesses for the grand jury. You don't ever do that. He did say the testing that had been done by the FBI, which the firearm was beaten with a mallet and destroyed. Yeah, without preserving any evidence of its condition when the accident occurred. Well, that's. I mean, I don't know. Throughout his testimony, he referred to a video he prepared with the prosecution that depicted a different firearm from the one that was on set. Haig omitted several essential facts that the testing, including the FBI testing, established that the gun did fire without a trigger pull when the firearm was fully loaded with 6 rounds, as it was on the day of the incident. Now, is he saying the FBI guy committed perjury? Which, I mean, like, shocker, he's a Fed. No, I think what the argument they're trying to make is when you've got, you've got this bad boy. You got a single action army, okay? I think his argument is, let's say you had pulled it, let's say it was cocked all the way back. Let's say it's cocked all the way back, ready to go. And you pull the trigger. If you hold it and you set it down gently, like that, would that be enough to set off what's in the chamber? And the answer is yes. You could strike it hard enough to discharge it, but yeah, I just. Then also, let's go Brandon for $4.99 here. Saying, thank you, Brandon. Saying, Sean Patrick McMartin, did you drink your Guinness today, or are you a Lofty? I don't drink Guinness. Guinness is not that good. Not that good. Say, and I'm surprised you're not even in the. No, Luke. I'm not saying Michael Haig is the FBI guy. He's Lucian Haig's son. What this is implying here is saying that the gun did fire when the fire was fully loaded. Okay. That the FBI testing also, including the FBI testing saying the gun was able to fire. That's different. That means the FBI agent was involved in that testing. Because remember, he said he hit it with a hammer. And he's going to have to say, yes, it did. Like, they're trying to argue almost that, yeah, it did fire. Which I find it hard to believe. So, that's the one we're getting at. Mr. Reese's black and tans are great. Lucas saying, I think he admitted that had happened at Hannah's trial. Well, no, he admitted, like, I had to hit the hammer so hard I broke it. So, you did a few pints at a snake bite. Yeah. But Mr. E is saying the black and tans are great. That's like going out on Martin Luther King Day and ordering the equivalent of a drink called a Klansman. The black and tans were horrible, horrible enforcers of British law in Ireland prior to the Irish Civil War. So, be careful. If you go to, it shouldn't happen here in America, but like, you go to the wrong bar in Northern Ireland and they would beat you for this. So that's, you gotta have a Guinness. Guinness is not that good. All right, so let's keep going here. Notwithstanding this fact, of which both Haig and the prosecution were unaware, Haig testified repeatedly the firearm could not have fired without a trigger pull. Further, Haig admitted that the manner of the firearm that fired the fatal wound was rounded, which would make it easier to fire. Ow. The hammer was rounded, meaning that it was rounded. It was manipulated, and I don't think that would be the case here. Without any support, however, Haig testified that the hammer had been broken during the FBI testing. An impossible conclusion to reach, since the FBI did not inspect the parts of the firearm or preserve any evidence about the internal parts of the gun. Well, they did, and it wasn't until before it could, yes, and this part is true. Before it conducted destructive testing, it had not done any of that. And that's a fair statement. They really hadn't. So until they got it and they took it in the shop and they started beating on it and broke it, there actually hadn't been anything performed. They hadn't done anything on it, but I don't think they had received it yet. Rather, as the state knew, the gun was new when Seth Kennedy provided it to Rust. Yet the internal components of the gun were inconsistent with stock parts, showed significant signs of aging, and showed clear signs of being modified and filed down. Now, that's something that any gun you buy, this can happen to. Sometimes it's not a big deal. But sometimes if they have done these modifications, it could turn something you bought into a machine gun in a heartbeat. So, you have to be careful what's modified out there, because you can modify a gun to do a lot of things. You can modify a gun to have a you could take a single action. You can modify it so it's got a very, very light trigger pull. Just barely just breathing on it and it'll go off. You can change the sear engagement. So as you're cocking the hammer, a sear, it might slip off because you mess with it too much, and immediately as you're cocking it, it flies forward and goes off. Or a semi-automatic firearm. If you mess with it, you could turn this into something where it's bzzz, full auto, just burr the whole way through. If there's signs of being modified, that's a big problem. There were show clear signs of being modified and filed down. Well, this is my question to you: what'd your experts say was filed down? What part? You don't file the whole gun down. Images of the firearm after testing showed filed down hammer notches that would have made it easier to fire without pulling the trigger. Most notably, the full cock hammer notch. The bottom of the hammer was completely filed off. Compare the images of the hammer to other parts of the Rust gun below, and notice any obvious points. So this is stuff that came from the original. We already saw this stuff there, okay, guys? These are things that we already looked at. But this is the hammer, and here are the engagement spots, boop, boop, boop. And this would go down here. And and it would bounce along on those and catch. A close-up image of the Rust gun showing filed down full cock notch and filed down notches. Is it filed down or did it shear? It looks like it went, because of the way the metal was being pushed, it sheared. It broke off. It didn't crack, it sheared. So I don't see how it's saying it's filed down. But I mean, like, you can see this here. Here's the differences. You know, look at this one. Look at this one. Look at this one. Look at this one. They're the same. This one's a little different than that, than that, than that. Okay, well, ultimately, what's the issue here? Well, there's this, there's this, there's this. And there really ain't this. So, I mean, yeah, that's a significant thing. To argue that's filed down, it just snapped off, though. I just don't understand what the prosecutor or the defense team is trying to do with some of this argument. But once again, these guys are not gun people, so I think there's a problem there. It's altered, yeah. Yes. No mandate says Medicare mask is for $50. Oh. So the prosecution failed to explain that the elimination of these notches, which appear filed off, which that's a fact, not an evidence, would have made the gun significantly easier to fire and prone to malfunction. Moreover, the prosecution failed to explain that the hammer showed signs of rough tool marks, including file marks that are consistent with the manipulation. Which, okay, it happens sometimes. You know, guns are machine made, Industrial Revolution, same thing, you know, made all over the place. Every once in a while they don't fit right. Ah, there we go. The prosecution concealed this information from the grand jury and presented only Haig's paid for and founded speculation that the damage occurred during FBI testing, when the FBI made no such observation. Yet it broke when the FBI tested it. And neither Haig nor anyone else presented the gun. Well, why, if they're just bringing it, who cares? The gun would have operated normally on set. Well, I mean, if it was messed with, maybe, but it does sound like the gun, like, it doesn't sound like there was anything to show it had messed with. I mean, the way I understood it, Alec Baldwin's attorney said, hey, this gun might have been screwed with, and they said, fine, we'll get it tested. In the meantime, we'll dismiss. And then they come back and like, look, you're fucking lying, it's back on. I do love the part where, like, he's paid. It's like, you're going to pay for everybody too, man. All your witnesses are paid. So, and then they say the next witness was Brian Carpenter, the armorer, who, like Haig, was paid by the state to testify. Okay, well. I mean, they're all paid. Everyone's paid. Like, I love it when prosecutors try to do that to a defense witness. Well, you're paid, aren't you? You get paid. We all get paid. We're not the Salvation Army. We don't work for free. And the Michelle Tracunas trial, that was one of the defense experts gave a banger of an answer back. It's like, I get paid just like you get paid. I have bills to pay. And the prosecutor had to shut the fuck up after that. It was brilliant. You know, Carpenter represents himself an armor and weapons expert, but that is not how he represented himself to the grand jury. Instead, he introduced himself as the owner of a production studio that makes movies, as if he started as an armor, but has since taken on bigger roles in the industry. Yeah, are you really going to fucking make that argument? That's kind of a weenie argument. That testimony is false, and she knew it. Carpenter's not an experienced film producer. His studio, 13 South, appears to have been involved in no more than one or two projects that were distributed to the public. Okay. Got it done faster than Rust. Safer than Rust. The studio's IMDb page lists 4 productions, 3 of which appear and have never been released. This allowed Carter to testify well beyond his experience with credibility he didn't earn. I mean, like, Really? Did he not, like... Yeah, so for example, Carter told the grand jury that the safety bulletins issued by the Film Actors Guild place responsibility for the firearm safety on the actor. In fact, SAG has made the opposite statement. See, SAG-AFTRA's statement on Rust charges. Okay. You know, we'll do that here. Let me see here. SAGAFTRA.org. We'll check this out here real quick. SAG... Film Actors Guild... AFTRA.org /SAG-AFTRA-statement -Rust -charges. Let's see here. All right, I can't get the load. It's not working right now, so whatever. An actor's job is not to be a firearms or weapons expert. Firearms are provided for the use under the guidance of multiple expert professionals directly responsible for safe and accurate operation of that firearm. The firearms bulletin makes clear the actor has no obligation to check the gun. The only right is to be allowed to witness it, if he or she chooses. That the weapons handler, not the actor, is the one responsible for checking the gun for use. The actor may point the gun at the camera with the approval of the first assistant director, which they're claiming David Halls gave here. And the armorer, okay. And the first assistant director, Halls. Well, yeah, they're exclusively responsible for firearm safety. Yeah, but still, you're charged if you're an individual person. And I don't think, like I told Lofty, I don't think they're going to be able to come in and say, look, we've got our fancy actor rules. That's good enough, people. I'm very... Then it says spoilers. That's not what the bulletin says. Well, I'm going to try to enter it again because I want to see what it says. All right, let me try this again. SAGAFTRA.org /SAG dash oh, come on, you fucker. We're almost there. SAG-AFTRA statement -Rust charges. Oh, hold on here. SAGAFTRA.org /. Okay, guys, I think we actually got it now. Finally. Okay, yeah, here we go. Here we go. All right. So, let's see here. So, well, this is SAG-AFTRA. That's the Actors Union. Okay. The prosecutor's contention, an actor has set a duty to perform mechanical stuff is wrong and uninformed. An actor's job is not to be the firearms or weapons expert. Firearms provided under the guidance of multiple professionals. Okay. I mean, it sounds like it's what they're saying. Well, I mean, I'm just saying, you guys are saying that's not the case. Looks like it might be the case. I don't know. I'm just double checking, and it looks like it for right now it is. Lofty is God. Yeah. Some God. You're pretty boring God then. And then saying if it's absolutely necessary to point a firearm at someone, consult the property master. Or the weapons handler, or the other safety representative, such as the first assistant director or stage manager. Somebody you think you might have to be involved is the director. The person in charge of everything, like, hey, we're going to do this. It's his thing, ultimately. You'd think you'd want to tell him. Carpenter falsely testifying in the SAG safety bulletins bar actions for pointing the weapon, anything you're not willing to destroy, and asserting that it's the actor's fault to discharging that weapon because he's in danger of it. Well, because he's in charge of the firearm. So Morrissey elicited the false testimony from Carpenter about these issues as well as others, despite knowing it was false and potentially... Well, knowing that was false without presenting the contrary exculpatory evidence. The next witness Morrissey called was Lane Looper, member of the Russ camera crew who quit the production the day before the fatal accident. Despite Looper's absence from the set on the day, his relatively narrow role as an assistant cameraman, she treated as an expert on all things related to film safety. And yeah, it's not really going to be unless he's... Did he go back to school for it? Did he, has he had a job since then? I mean, they seem to act like they've got receipts. She even asked him to answer specific questions on firearm safety rules about which he had no expertise. Don't point guns at people. I mean, this is not hard. So... Yes, the prop master was Sarah Khanna. So, meanwhile, Looper's bias against Russ and its producers arose before the accident even took place. He quit production because they wouldn't pay for hotel rooms for crew members who lived less than an hour away from the set. Within days of Hutchins' death, Looper began airing his grievances, which I think is hilarious. Like, I know people who drive an hour to work every day. They make do. This guy needs to chill out. Like, it's not that bad. At several points through testimony, Looper made comments that were stricken as irrelevant and prejudicial. So, Morrissey's presentation of the grand jury just included a single eyewitness. Okay, that's actually not a problem. Like, David Halls was in the room, right? Like, you wanted him there? Like, there's only so much you can do. Like, the eyewitnesses, what are they going to say exactly? Like, what would you want them to do in this spot? I don't know what you want out of them. Neither Morrissey nor Adiago discussed the grand jury, however. Adiago is suing Baldwin for money damages. I'm assuming everybody in that church that was shot is suing the crap out of him. And rightly so. The state's final investigator was Connor Rice. Is a paid private investigator and a former Albuquerque police officer with a sordid past. Rice has no first-hand knowledge of the event and was not involved in the initial investigation, and he testified about both. Well, what did he do? What did he do? Like, what did this guy do? Like, what? Whatever. The special prosecutor's attention withheld exculpatory evidence. They didn't present any of the evidence, the witnesses listed. They didn't ask proper questions to elicit exculpatory information. Morrissey never contacted Baldwin's attorneys to ensure they were available to testify. The court ordered the state make them readily available by Zoom. The state knew it was obliged to do so, but excluded these witnesses from the grand jury proceedings anyway. The state did this in two ways. First, Morrissey did not explain the meaning or purpose of Baldwin's alert letter to the grand jury. She introduced the letter at the beginning of the process by simply stating, "This is a grand jury alert letter from the target for your consideration." That means they probably didn't even look at it. She then proceeded to read the alert letter into the record verbatim without explaining its practical significance. I mean, that's just... She introduced the letter at the beginning saying there's a grand jury alert letter from your target for your consideration. She then read the letter of the alert record in the verbatim without explaining its practical significance, why it had been submitted or why it was being read, or what the grand jurors were supposed to do with it. Nor did Morrissey explain that the witnesses identified in the letter were available to testify and that the grand jury was obligated to request. Well, that's a bit of a problem. If she's breaking the law and not saying what's going on or what has to happen, yeah, that's not a good look. Instead, Morrissey did the exact opposite. Before reading letters, she had already dictated the witnesses who would be. She said, "This morning I'll be presenting you a case where Alec Baldwin is the target." The witnesses in this case will be, Marissa Popel, Michael Haig, Brian Carter, Ross Iago, Lane Looper, and then Connor Rice. She said Morrissey made no effort to explain the letter's purpose. She simply stated that concludes the grand jury evidence alert letter from the target. So, I mean, it's... I wonder if there's case law that says she can just read it like that. I mean, she presented it to them. I wonder if that's going to be enough to get her out of this. That's a... I mean... Oh, well, because, yes, you need first-hand knowledge to testify, especially not at a grand jury. I mean, at a grand jury, usually you don't have everybody. So there's a lot of hearsay that gets introduced. I also don't know if she read the letter, it sounds like she complied. Maybe not the way the law explicitly stated, and maybe not the way, like, you gotta be like this. And she came in like this. Maybe there's case law that allows Carrie Morrissey to do it that way. If not, I do have a massive problem with it. But notice they came up with like, oh, she didn't do anything for the grand jury. And then it's like, well, now they're like, well, she read the letter and she read it verbatim. Then she did something. Which really, they kind of undercut themselves, I would argue. She's not normally a DA, so that come into play here. That's a very good question, but I would make the argument if I'm Alec Baldwin's attorneys, she's a defense attorney. She would be screaming and hollering like a stuck pig if they tried to fuck her client over like that. because she's a seasoned New Mexico attorney. So I don't think that's going to work for Carrie in that regard. She can't go, well, golly shucks. She's a seasoned litigator. I mean, Andrew Branca said, I would hire... He already knew about her because she won the Dean Cummings trial. If he got charged with a shooting in New Mexico, he would hire her. So she's not a spring chicken. Had she read and interjected too much during the reading of the letter? Yeah, well... So, she doesn't explicitly tell them what they can do. They're like, it depends on you what you want to do. Do you want to take a break and consider the alert letter, or do you want to just begin hearing witness testimony right now? Morrissey never explained or even attempted to explain what it meant for the grand jury to consider the letter. That they could ask for any witnesses or a document identified in the letter, and in fact were required to order exculpatory evidence to be produced. Once again, her statement communicated that the opposite was true. Her message to the grand jury could consider the alert letter, or just begin hearing witness testimony. The state never explained that there was a third option, the most critical option of all under the governing law. The grand jury could consider the alert letter, hear the witnesses the prosecutor identified, and direct that the witnesses' testimony and document evidence identified in the alert letter be preserved. So, after returning from a break, the grand jurors asked about typos in the letter, making it clear the jurors had no idea what New Mexico law required them to consider. After discussing the typos, Morrissey stated that she can't fix the typos in the grand jury evidence letter because it's not ours. And that's fair. It's not our letter. I don't know what they were trying to say. Again, conveying the impression the letter was merely a formality because she commenced the actual hearing of evidence she wanted to present. Morrissey then asked the grand jury, do you have any other questions? Anybody else have any other questions? Do you do you want to tell us how you want to proceed? In response, the foreman stated, I think that if that's the end of questions about letters and warrant letters, we probably need to proceed with the witnesses if that's okay. Meaning he clearly didn't know what the fuck was going on. So, second, Morrissey diverted the grand jury from hearing exculpatory evidence as well as other evidence that had been helpful to Baldwin by refusing to facilitate the grand jury's repeated inquiries into the witnesses and documents identified in Baldwin's alert letter. Instead of giving the grand jurors questions and the information they requested, she would redirect such inquiries to her own witnesses. To her own witnesses, like, where are we going to see that? Because that's the thing. Like, I want to see the actual transcripts of this. I know they cite them, but I'd love to see them. Because this part is a little revealing, but it doesn't, I guess, I need to see it because this is not enough context for me, I don't think. At one point when, during Deputy Hancock's testimony, grand juror asked, so the bottom line is responsibility, making sure these guns, these bullets are not live, are up to what, David Halls and Hannah? The prosecutor, the truthful answer to that question is yes. But rather than ask the jurors that they wanted to hear from Halls directly, or inform them this was an option, Morrissey stated, we are going to have another witness to address those issues for you. Don't you worry. That's kind of shitty. Don't you worry your pretty little head. We have an expert who works on movie sets, and he's going to answer those questions for you if that's okay. The witness you're referring to is Brian Carpenter, the guy who came in and, yes, his false answers that question blaming Baldwin would have been refuted by Halls. The relevant industry safety bulletin and SAG. Notably, at the trial of Hannah Reid, one of the jurors publicly stated, at the trial, one of the jurors publicly stated the jury's verdict was based on the fact that it was Hannah Reid's job to check those rounds. And, well, there was only one person who testified or gave an interview, and that's the one Mexican-looking dude. So, I mean, but yeah, nobody was surprised at that one. So they point out that in summation at trial, Morrissey argued that Hannah Reid is the autonomous decision maker with regard to gun safety, and that she was responsible for Halyna's death because it was foreseeable that Baldwin would not check the gun. They're sending comments with cases, statutes, and rules. I'm only half paying attention. It's just, when you're rethinking this, Baldwin loses because of piss poor grammar. I don't think so. I mean, but I've read this through already, and I'm just trying to think about it again as I'm highlighting stuff. Like, it's just. KT says that's not what the juror said. Well, no, but the one juror's like, I work at Los Alamos. Safety's a big issue. You got to take care of safety. Claude Simeon for $5 saying, why is it allowed to lead the jury because experts are paid? Isn't that the wrong implication on either side? Yes, it is. But the state always does that because they're going to argue, well, the money, defense money's dirty blood money. It's evil money. And they're not nice people. And, we're the heckin' good guys. Our money comes from you because we steal it from you at gunpoint. Therefore, it's better. So, when and these questions get interesting. When the one grand juror asked, shouldn't somebody have seen the difference before it went into the gun? Morrissey again deflected the question away from Halls, who previously testified he should have been checked before handling, to Baldwin. So instead, she said, like I said, we're going to have more testimony that will hopefully help with that. At no point did she explain to jurors they could hear from Halls directly if they wanted to. Morrissey later introduced testimony Baldwin could have determined the difference between a dummy and a blank, without any basis for that testimony, contrary to at least one other person on set told SFSO. Well, I think you could still tell the difference between a dummy and a blank. It's not that hard. From behind, sure, you might not be able to tell. So, he said you wouldn't be able to tell visual representation if they were dummies or live rounds. On another occasion, another juror asked, when Alec Baldwin refused to look at the gun that was handed, that was allegedly clear, and they gave it to him to reinspect, how would he inspect the gun? Would he like take all the bullets out into his hand and start shaking them, or would he just open the chamber and look at the top to make sure it was kind of seated all the same and no notice, no inconsistencies? The question itself is troubling because it reflects at least three material misunderstandings. That Baldwin refused to look at the gun, that he was required to inspect it once it was handed to him, and then finally that there is a protocol for actors on how to check weapons. I don't think I'm pushing it that far. So, just these misunderstandings are a direct result of false testimony from Morrissey's witnesses, and Morrissey had a duty to elicit truthful evidence to rebut them. For example, had the grand jury been able to question Halls or been referred to affidavits about the accident, the correct safety bulletin or SAG's official views, It's had they, based on their interpretation of the rules, rather had he no obligation to check it in the first place and therefore was never asked or told to check the gun. Nor given a protocol to do so. But Morrissey again says and I kind of get the feeling when I read this before, it's almost like the grand juror's like, hey, I got a question. He's like, is it okay with you if we address that with someone else? Don't worry, I got somebody else coming. Don't worry. And you're like, but I got a question. No. Don't worry, I got somebody coming for that. I mean, that's a massive problem here. So again, she was referring to Carpenter, whose false testimony would compound the grand juror's misunderstandings. And then when Carpenter testified to Hannah Reed's trial and testified that Reed and Hall's not the actor have the obligation to check and clear the gun, which is the opposite of what he told the grand jury. Carpenter is testifying at trial that actors can check the gun if they want to. However, those safety checks are more of a warm than fuzzy feeling for them. And that's rare. You clear the weapon with at least 2 representatives on set. Anybody that wants to see it get cleared, it gets cleared with them at their request. But it's generally going to be your first AD and the director of photography. Then Morrissey says, are you testifying that you showed the individual dummy rounds to the AD and whoever else wants to see? And he says, absolutely. Then Kerry Morrissey says, and the actor, he said the actor may or may not be on set yet, but when they get here, this is done with the actor as well. And sometimes you'll have an actor that says, nah, I don't want to see it, and they just brush it off. I'm trying to remember how he did this. Yeah, I don't remember exactly how he said this, so I'm not saying this 100% right. And yeah, the actor will just brush it off. As long as you've done your safety check with at least 2 other people and moved through the process, then you've done what you should have done. Whose responsibility is to ferret out live rounds on a set? It's the armor's responsibility. Morrissey did not prevent that critical exculpatory evidence to the grand jury. And she was so determined to keep Halls out of the picture, she cut off her own witnesses at their testimony, focused on where Hall's statements could come in. And she said, you've seen this video. Is there anything that you seem problematic? And this is Ross Adiago, the camera dolly grip guy. Remember, not the gorilla grip, the dolly grip. If this is all true, Morrissey's just as scummy as Bringer and Lunchbox. Far worse than those two. He says, and what is it? He's like, there's a number of things. First of all, as soon as Baldwin emptied that firearm and we had to reload, Dave Hall should have called cut to give everybody that moment to safely reset. And this is that scene where it shows Alec Baldwin coming out of the, he's got the gun and the door flies open and he's just like, wha-bow, wha-bow. And then you can hear him like, I mean, it sounds like me trying to run up the side of a hill. And he's got 30 years on me. He's, and he gets up to the top and he's like, bang, and he goes, motherfucker. But then he comes down, running around screaming like, hurry, oh my God, hurry, guys, we gotta redo the shot, That part, I get it. He wants to preserve the lighting and try to redo the shot in that right situation. But, that's not safe. And that's when Brian Carpenter says when someone's yelling at you to go fast, that's when you should go twice as slow. It appears though the armor is putting rounds in the same fanny pack or pouch as the live ammo she's pulling live ammo out of. David Hall, who's the first AD, is in blue jeans and a black shirt, is not. And that's when Carrie Morrissey says, and keep in mind, we're here for Mr. Baldwin. Point out your what is Mr. Baldwin doing in the scene? What is concerning to you? So, it's interesting. So, she also steered the grand jurors away from other critical evidence identified in the alert letter. While Rice, Morrissey's paid private investigator, was testifying, a juror made a direct inquiry about Sarah Zachary's responsibility. And say, looking back at the alert letter, there's a notation that Sarah Zachary, the prop master, was also supervisor for Hannah Reid, but nobody's talking about her playing this, so you know where I'm going. In response, she indicated Rice may not be familiar enough with the relationship between the prop master and Armour to answer that question. Then she stated, we may have a witness who may be able to answer it. It's like, yeah, the witness should have been told Zachary, who made exculpatory statements on this topic. Instead, it was Lane Looper, who Morrissey offered to bring back to answer the jurors' questions about Zach's role. So, I'm just trying to remember, like, yeah. When the same grand juror asked an even more specific question about Zachary, Morrissey redirected the question to Rice and then peppered Rice with questions about Zachary that Zachary herself was in the best position to answer, and Rice had no foundation for. Do you have any information of the firearms training that Sarah Zachary has? Do you know whether or not she's ever shot a gun? Your understanding of where she procured the prop guns? Did Miss Zachary bring dummy rounds on set? You know, all this stuff. At no point during the exchange did Morrissey explain that Zachary herself was available to testify, and other witnesses who had communicated with her could testify. You know, Morrissey was obligated to present these witnesses to the grand jury wished to hear from them. And yeah, I think they're saying they want to hear from, but they're not explicitly saying it. So is the court going to treat this like when you ask for a lawyer, like, I think I need a lawyer. Should I get a lawyer? No, you have to say, I want a lawyer. I mean, I don't know if the law says they have to say, we want to hear from Sarah. Maybe they do. I don't know. Or that the grand jury had the obligation to request the evidence that might be exculpatory. As a result of the diversions, they never heard from the film's director, its producer, the first assistant, or its prop master, even though they offered exculpatory testimony. But rather than facilitate the grand jury's inquiry into the witnesses, Morrissey did everything in her power to ensure the grand jury never heard from them. You know, Morrissey withheld over a dozen exculpatory documents that were relevant to the grand jury's inquiries and contained the specific answers to many of their questions. Good job. Good job, Carrie. I mean, I kind of get the feeling like this is... There's no way this could all be bullshit. I'm just saying, there's no way this could all be bullshit. There's a lot of problems I have. There's no way I could just see this is all bullshit. So, this viewer says, I think Hannah lost track of the live rounds and Sarah got a hold of one and loaded into Baldwin's gun. Yeah, but I mean, like I said before, I think Hannah was playing with, and she was making rounds. She was using her, because they talk about it, that she has this, she had the connect, she had one bullet puller, and she's sitting there taking a loaded round and, taking it and then pulling it out and like pouring out the powder and then seating the bullet back on there and making a dummy round. And she was doing that and doing that and doing that, and she probably forgot. And after a while, doing this all the time, and then, I guess there were a couple of live ones, and she's like, oh yeah, these are all dummies now, and she threw live rounds in the kit, and that's how Alec Baldwin had multiple live rounds on his body. He had one in the gun, he had a couple in his bandoliers, yeah. So I think that's what happened there. So that's what I think happened ultimately. So Morrissey supercharged these failures by issuing an improper instruction on a critical element of the statute. Specifically, on 3 occasions, she instructed the grand jury to return a true bill. So an indictment, it must find probable causes to each of the following elements. Well, I mean, that part's correct. You have to find probable cause, but it's that the target discharged a firearm during the production of the movie without first verifying the firearm contained no live ammunition while the firearm was pointed in the direction of another. The target should have known the danger involved from the target's actions. The targeted act with a willful disregard for the safety of others. And 4, and finally, is the target's act caused the death of Halyna Hutchins. So, what is the... I thought there was a footnote for that. Without first verifying the firearm contained no live ammunition was pointed in the direction of another. So, Morrissey included the italicized language, even though she had successfully argued to the court that Baldwin's requested instruction concerning subjective knowledge was improper, because it assumes a factual basis of a negligent act was failing to check the firearm for live rounds, and that any deviation from the UJA by inserting such language was unwarranted. Well, if this is explicitly what's in the UJI, she may have highlighted it, but that's improper. I'd argue not fair, but is it illegal? No. Is it, sanctionable? No. So, the instruction Morrissey gave to the grand jury deviates from the UGI and violates the court's order. It also places an affirmative duty on Baldwin to check the gun for live bullets and therefore obtain subjective knowledge about the very thing Morrissey told the grand jury the court has nothing to do with the ways in which the court intends to prove his negligence. And the state's expert at Hannah's trial testified that was not the actor's responsibility. Well, So on January 19th, the grand jury returned an indictment. Yep, and we knew that. The indictment says it is based on the testimony of Hancock, Carpenter, Looper, Ediago, Haig, Mercer Popel, and Connor Rice. The grand jury did not receive the favorable exculpatory documents that the state had an obligation to present, nor did it obtain and request that information. Jeez. Why is that all fucking goofy? It's all falling off. Holy cow. So, she jumped right in front of him. Yeah. He's fucking blaming Halyna for him shooting her. No, he's not. He's not doing that at all, guys. That's not what he's getting at right there. They point out that the state's intention withholding of exculpatory evidence subjects the indictment to judicial review, and I think that's true. The indictment is built upon a showing of bad faith, and it sounds like there's some bad faith there. The state's conduct throughout the process demonstrates its dishonest belief, purpose, and motive. From the moment it began, Morrissey has sought to prejudice Baldwin. The list of misconduct leading up to grand jury is long and disturbing. She announced her decision to pursue an indictment in violation of the rules governing the process. The grand jury court chastised this conduct, meaning the court said, fucking knock it off. So she had already been warned not to do that. She made public comments regarding his guilt. You're not supposed to do that. The prosecutor should refrain from making extrajudicial comments during a trial that promote no legitimate law enforcement purpose and serve solely to heighten public condemnation of the accused. That she sent Baldwin the target notice that violated New Mexico law by excluding the 48-hour deadline, even though she already acknowledged she had never seen this done before, and it served Hannah Reed a deadline. She filed an unprecedented motion to do a one-sided voir dire, the grand jury veneer, to improperly influence them. She was chastised again. She twice violated the court's order to refrain from disclosing information about the grand jury hearings to the public. So she was told to stop. She rejected almost the entirety of Baldwin's alert letter by seeking to preclude nearly all of Baldwin's exculpatory and favorable evidence. You know, she was told she can't do that, and she cited overruled case law and overruled statutes. She refused to contact any of the witnesses that Baldwin identified in the alert letter, despite making sure they were available to testify. They didn't do that. She told the media the state was motivated to pursue this prosecution to humble him, and because they found him arrogant and they wanted to give him a teachable moment. The grand jury term was set to expire just one day after she intended to present her case, and she didn't have enough time to get it done, so we had to wait. All this misconduct occurred on the heels of the state's initial prosecution, a bad faith debacle in which the prior prosecutors resigned after violating the U.S. and New Mexico constitutions. Well, yeah, but I'd argue that one's not fair because that's not her conduct, but yes, the state as a whole did improper things. So, yes, can you consider that to the state? Sure, but I think you could probably get rid of this one. If I was Alec Baldwin's attorneys, I would probably get rid of this one, and you'd probably be fine. I don't think that this other stuff here is already problematic enough to me. So, and then she doubled down on this conduct by violating the standards governing her presentation in the grand jury. Yeah. The court rejected nearly every argument the state presented leading up to the process and explained legal standards that govern the presentation. As described above, however, the state violated those standards over and over. Morrissey ensured the grand jury had no understanding of its obligation to request the relevant evidence. Then she excluded the exculpatory and favorable evidence. The witnesses who would have given a favorable testimony about Baldwin, well, they were excluded. I mean, all kinds of things there. Every favorable or exculpatory document was concealed or only partially presented. Well, see, now that's a problem. Was it? I thought you said they didn't do anything with stuff. Like, partially presented. Like, yeah. Every favorable fact was hidden, and all the grand jury's inquiries about exculpatory information were rejected, and witnesses who best represented the facts had no foundation for giving answers. The state had one goal: indict Baldwin no matter the truth, no matter the rules or court rulings, and no matter what cost it took. If the state's conduct here does not demonstrate the level of bad faith to subject this judicial review, it has all been impossible to imagine a series or set will. I'm trying to think, what would I do right here if I was a judge? I mean, I'd be very, very unhappy, but I don't know if I'd dump it. If the state's conduct does not demonstrate the level of bad faith necessary to subject an indictment to judicial review, it is all but impossible to imagine a set of facts that would. I think that's fair. If this isn't good enough, then what is? Now, the indictment must be dismissed. I don't know about this part, but I think they might be able to show it. This is not a good spot for them. Yes, Dylan says they keep setting up for these big bombshells, and then I'm walking them back. Yeah. Dolly saying, hi, Dolly, saying, can you explain the going back to grand jury portion if it's dismissed? Oh, okay. So I think Dolly asked this question to me earlier today. So it's already been dismissed once. If it gets dismissed again, what happens? Well, there's no turning back. You generally only get 2 shakes on this kind of a thing. You can indict the first time and then dismiss that indictment and then refile an indictment. So you get 2 shots. But if you, now the court says, well, we're not doing that, and you screwed up, it has to be dismissed again. Well, now it's dismissed with prejudice. You can't keep re-indicting someone. The indictment, like, you could present to a grand jury 55,000 times, and the grand jury could say, no bill, no bill, no bill, no bill, no bill. But once the grand jury says, here's your bill of indictment, and you have it in your hands, you have to do something with it. Okay? So now you've got your indictment, but let's say a couple weeks in you realize it's a bad idea. You dismiss. Okay, well now you've got you're 50% of the way there. You can only re-indict that person one more time. Now, getting an indictment, I can present you to the grand jury another 10,000 times and get no bills. And then on the 10,001 time, you give me another indictment. Okay, now I have to see that one through. And I either get a plea or a conviction. Because if I dismiss it at that point, it's dismissed with prejudice. That's just the nature of it. Absent something really weird happening, and generally it's not going to matter. And I think this is a fair sanction. Your case is done. Same thing for civil suits. You get one chance to file. You can dismiss and file again. But after that, absent really big circumstances, you're done. You don't get to keep having multiple bites of the apple. Sula says that's a lot of ham sandwiches. Yeah. Yes. Poor sad Clyde. Hold on here. Hey, Clyde. Come here, buddy. Come here. Hey, come here. Hey, come here. Dude, people want to see you. Come here. Hey. Up here. Come on. Oh my God. Holy Jesus. Hey. I'm trying to get to the... Come here. Come on. Come on. Come on. Up here. Up here, dipshit. Come on. Whatever. Okay. Nobody's getting them. You don't get to see them now. Jim says, I never heard of a case getting taken back to a grand jury after a no bill without some kind of new evidence. Well, I mean, I'll say it like this. The political climate can change. If the political climate changes and something becomes unpopular, you might be able to squeeze it through a jury now who doesn't like that topic or that person. But yes, generally you require new evidence. That's generally like the special thing there. So.
What are you doing?
He's not, baby. I'm not gonna. Okay, fine here. Yeah. All right, we got him now. So, but Jim, normally you're right. And James says the state calls key craft services. Yes. Now. Yes, and then it keeps going, though. Under New Mexico law, the grand juries are a foundation of preserving individual rights, yes. But the grand jury method cannot function when prosecutors conflate their role as an aid to the grand jury with the role of the grand jury itself. The grand jury is not meant to be the private tool of a prosecutor. Yeah, except guess what? It is. Guess how prosecutors view it. The grand jury does not function as an arm of the prosecutor. Guess what they think? They think the otherwise. Entirely. Clyde, what do you have to say? Do you agree? What do you think? All right. So. But they point out that's what happened here. The state deprived the grand jury of its ability to accurately and independently assess the government's evidence of probable cause. And instead used the grand jury as a private tool. So the indictment should be dismissed for two reasons. First, the state unlawfully deprived the grand jury of its critical evidence to disprove the charges or makes an indictment. And second, the state conducted the grand jury process in an unlawful manner by providing an improper charging instruction regarding critical elements. Now, that's important, the charging instructions, because it's no different than a jury trial. If the jury gets an improper jury instruction, guess what? It's not a valid prosecution. It's not a valid conviction, and it has to come back. Jury charges being improper are fatal. I mean, that's generally a big problem. What are you doing? Spasmatron. Hi. Can I help you? Huh? Jeez, buddy. You can relax. You can relax. You can relax. You can relax. I promise you. Can I get a kiss? Mwah. Yes, Ag is correct. Jack Smith used the grand jury in D.C. as a way to get around a Florida grand jury. Yep. So. Oh, that was a burp. Excuse you. So, unless the the states, and this is just more unlawfully depriving Baldwin of this option here, and they keep talking about this here. The indictment must be dismissed because the state withheld exculpatory and favorable evidence, and she intentionally violated her duties of withholding exculpatory material. And it prevents a grand jury from being able to assess probable cause. And they said Baldwin's alert letter described piles of documents. You went down, buddy. I got you. There you go. Piles of documents and more than a half dozen witnesses who had information favorable to his defense. I don't know. Based on the way these guys testified at trial, like Sousa and Halls, that might be an argument that could be made differently by Carrie Morrissey. That, based on the way these guys testified, I don't think helped Alec Baldwin. Joel Sousa's testimony, I don't think was favorable to Alec Baldwin. David Hall's wasn't favorable. Ross Adiago's wasn't favorable. They weren't favorable based on the way they did it at trial. So, that's something I would make an argument for there. But I don't know if in hindsight that Carrie Morrissey can go back and patch up the problems like that, because these are problems. There are witnesses who saw Baldwin's conduct on set and said he handled the gun safely. A witness said that he, not Baldwin, was responsible for checking the firearms, and that Baldwin was not at fault. There are documents corroborating Baldwin's statements he had no control over production of the movie, other than the right to give limited creative input about stars in the script. The guidelines and industry statements made it clear Baldwin had no obligation to check the gun. There are also documents and testimonies showing the set was safe. Well, according to who? I'm betting a lot of those documents were pencil whipped and fraudulently done. The list of favorable evidence goes on and on and on. And on. Sousa was they say Sousa was standing behind Hutchins when the gun went off and struck by the same bullet. His statements to law enforcement following the incident support Baldwin's case. Similarly, Halls is the only witness other than Hannah Reed with first-hand knowledge of the condition of the gun before it was given to Baldwin. I don't know about that one, because remember what David Hall said. Hannah kind of showed me he said he kind of showed her the gun, but she didn't really fully show it to him, and Hannah gave the gun to Alec. So, I don't know about that one. I'd argue if that one's not correct, that's a big problem for Alec Baldwin. He's also the only person who was required to inspect the gun besides Hannah before it was handed to Baldwin. And he admitted he failed to properly do so. Yeah, so... he testified he was negligent in checking the gun because even though the cylinder wasn't fully rotated, he let that safety check sort of pass. Yeah. Morrissey was required to elicit his exculpatory testimony from Halls and Sousa. She was also required to provide the grand jury specific documents identifying the letter. And this is just further, for example, in the same interview, these are all just parentheticals. These are just examples of stuff. So we're not doing those. For example, in the same interview, Halls told the state he had failed to properly inspect a gun before it was handled to Baldwin. He told the state he feels some culpability for her death since he, not Baldwin, was the last line of defense. Well, he pled out. He took his hit. He also thinks Baldwin should be criminally prosecuted. Okay, well, that sucks, but that's not the standard here. Like, oh well. Sarah Zachary, the prop master, supervised Reed, is the only person who claimed to witness Reed load the gun before it was brought into the church. Immediately after the accident, she told Detective Kano that, based on what she had witnessed, she believes Hannah Reed might have messed up by shaking 2 rounds at once while checking for dummy rounds as she loaded the gun. So the grand jurors need to hear these facts from Sarah Zachary, and they repeatedly asked about her, but Morrissey prevented that from happening. Instead, calling back witnesses who had no personal knowledge about the grand jurors' inquiries. Sarah Zachary's testimony would have likely established Hannah Reed was an intervening cause in the chain of events that led to Halyna's death, yet that was concealed. Same song, different verse for Baldwin's other witnesses. Well, yes. For example, Morrissey knew that Ryan Smith, one of the producers, would have contradicted testimony by several of Morrissey's witnesses, but that Baldwin was in charge as a producer. As Smith would have testified, Baldwin's role as a producer was limited to making creative decisions, and Baldwin was not responsible for hiring crews, enforcing safety protocols, setting the budget, or managing day-to-day operations, contrary to the false testimony from Morrissey's witnesses. No, but I bet he was also there to help draw in investment. So the OSHB report also stated that the corroborates this account that Alec was not directed. Oh. Nor did Morrissey's access facilitate grand jury access to Robert Schilling, a former investigator in the case who described the state's investigation as reprehensible and unprofessional to agree I still have no words for it. Well, who the fuck is that? Because anybody who's got a bad word to say about the state isn't automatically going to get involved. Like, who was he a investigator for? Because I don't remember that name. There's the Rice guy. So, she didn't inform the witnesses were available or make them available. And she punted the grand jury's inquiries into the state's hand-picked witnesses, whose testimony was biased and accurate, in most cases flat out untrue. In short, the state concealed substantial exculpatory evidence favorable to the grand jury. And their argument is that the outcome should and almost certainly would have been different. That's something I don't think you can prove. I know you'd like to think that, but are you sure? Answer is no. The court should therefore dismiss the indictment. Now, they found other cases where dismissing the indictment where this prosecutor failed to elicit exculpatory testimony that contradicted it. Yeah. Dismissing the indictment where the prosecutor prevented the grand jury from inquiring into facts. So, I mean, they're making a very good argument here, guys. Suddenly, Alec has no production responsibility. Well, I don't know. Watch Carrie come back and say this is all bullshit. Certainly she's going to. But I don't... Yeah, well, we're going to stop real quick. We got some super chats here we got to do real quick. Brandon says, more Clyde. Well, how you doing, Brandon? Well, glad to see you here still. Brandon says, stop eating Clyde's treats, you selfish son of a bitch. Never. I'm going to eat them all more! And Debbie says for $10, thank you, Debbie, for being here. Sorry if I missed this part, but don't prosecutors only produce their side of a case to a grand jury? Yes. The difference is in like New Mexico, Colorado, Illinois, and a couple other states, Alec Baldwin has the right to come in and make their case. They're allowed to send in what's called a letter. It's called an alert letter saying, hey, judge, here's a bunch of shit the prosecutor's not going to mention. We have the right to have the grand jury understand this. And the grand jury has the right under state law to provide exculpatory information. That's not true in any, like in Ohio. There's no obligation the prosecutor to provide exculpatory material to the grand jury. Meaning, literally, the prosecutor could just, like, present something, and then the grand jury's kind of left in the dark about exculpatory material. And that happens all the time, because we don't have a protection like this. This is something I think every state should have. This is beautiful. I love it. But it sounds like the prosecutor in this case kind of disobeyed the rules there, which is very weird because she's a defense attorney by trade. So it's like she would know better than anybody, because I'm sure she's had clients get fucked over in this situation. And yet she's out here now fucking over Alec Baldwin, which is just so weird. She would do that and not protect him. Like, not treat him like she'd want her clients to be treated. So, like I said, this is kind of weird. It's kind of weird. Kind of weird. So, yeah, if this happened in Ohio, none of this would have been an issue. There'd be no belly aching because it doesn't exist. Just a grand jury. No roles or rules. So, they're pointing out that states' bad faith withholding of exculpatory evidence alone requires dismissal. That's a very fair argument to make. Judicial review of an indictment is also permitted without a showing of bad faith where the target claims the grand jury proceedings have been conducted in violation of state law. Yeah. Looks like they have. Moreover, in such cases, the target is entitled to dismissal and not required to demonstrate prejudice. And I think that's fair, too. It's just, it was wrong. Give me, dismiss it. And for Alec, that's going to be important because this will be the second dismissal. So this is actually very big for him. So, the courts presume prejudice in such cases because structural protections of the grand jury statutes preserve the integrity of the system. And it's a structural error that you can't fix. The indictment should be dismissed on this separate basis alone. If it does, I think it's gone forever. And they've got a very good argument that she hasn't complied. Although, notice what they don't have in here. They don't have the grand jury transcripts. Normally you'd bring in like big block quotations of stuff. And they didn't do that here. And I'm trying to find a good spot where, like this right here. This right here, these block quotations of crap. This stuff right. Ooh. Wow, that did not go well. So, but this stuff here, this is considered a block quotation. The actual discussion that occurred and something that was cited on the record. Well, why don't we have that throughout? You think we would. That's something I have a bit of a problem with. Why aren't we talking about it in that way? And I kind of want to know why. Because it's almost like you're hiding shit too a little bit. Just a guess. They point out New Mexico law provides instructions that protect the grand jury's ability to perform its constitutional function. If the prosecutor is not adhere to the statutes and to ensure fundamental fairness, the structural integrity of the grand jury process is compromised, along with the grand jury's determination of probable cause. Thus, to preserve the integrity and independence of the grand jury, prosecutors must conduct themselves in a fair and impartial manner at all times when assisting the grand jury. Well, yeah. And the smallest prosecutorial error can have severe consequences for a target. Knowing the mere issuance of an unjustified indictment can inflict undeniable damage, including because the stigma can't be erased. The stigma can't be erased, but you might get convicted. And then that's really fucking bad if you're innocent. That would be awful. I mean, that's the worst case scenario. The state provided an inaccurate jury instructions regarding critical elements. Like I said, that's normally something to get a case overturned and sent back. The jury instructions were wrong. The refusal to present David Halls. He could have brought up a lot of information that is not the actor's duty to check the gun. There's all kinds of things here. The state knowingly failed to advise the grand jury of its authority. And that's the thing, too. I can't believe if... I don't know. I'm very surprised. Like, these guys are completely... If the state really did this, then he deserves to walk. Just for the punishment of the state, so it's made clear we don't put up with this nonsense. And if that, I would rather 100 guilty men walk than 10 innocent men get hemmed up. So be it. So be it. Just more and more of this attack on him. What the heck? Oh, I'm not sure what hit there. So, the grand jury process was flawed from start to finish structurally. And the structural integrity, this is a structural error, has been destroyed by the misconduct. She has undermined Baldwin's rights and eliminated the ability for a fair playing field. She disclosed confidential information to the public, including the existence of data of the grand jury. She tried to jam an indictment through in a 3-week period while trying to limit Baldwin's time to get an alert letter in. She tried to do the one-sided voir dire of the grand jury. She sought to preclude virtually all of Baldwin's exculpatory evidence. Well, a bunch of it got brought in. Taking the extreme position, none of Baldwin's witnesses, including Halls, had anything exculpatory to say. Which they did. They have exculpatory things to say. But based on what David Hall said at trial, I don't really know how exculpatory it was for him ultimately. The court ordered the parties not to disclose the contents of the grand jury. And it was highly disturbing because grand jurors had read the press and asked the court to sit on the Baldwin grand jury. Morrissey violated the court's order that same evening and disclosed this information about the grand jury, and the next grand jury day twice after being told not to. The madness did not stop there. After the court rejected the state's arguments and ruled the witnesses must be made available, she refused to adjourn the grand jury to allow time for stuff to happen under the law. She ignored the letters and plowed ahead, presenting her biased witnesses. Well, of course they're biased. They're her witnesses. And refused to provide the grand jury access to any of the witnesses or documents they were obligated to consider. They issued an improper instruction on a critical element of the offense. And after more than one day, they got the indictment. And I'm sure when Carrie Morrissey read out that letter, it was kind of very fast. I'm sure she read it very much like I'm trying to speed through her thing. Like, okay, yeah, 7 years ago, yada, 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 yada. Too long, didn't read. Boom, done. TLDR, there. So the state's misconduct through this prosecution occurred on the heels, violations of the U.S. and Mexico constitutions, the New Mexico law, and ethical rules. This is bad faith, just like the prosecutor before and the special prosecutor before. They both fucked it up, and now here comes Carrie, the third one in, and she fucks it all up. Because all she did was shit talk Alec Baldwin in the press all the time. And it's just, what more? Yeah, from Alec's side, how much more bullshit can I get? Morrissey, Carmack, Altweez, and Reeb could not hide their disdain. which is why they cut every corner imaginable to push their vindictive agenda. This is, disparaging him in the media when he asserted his rights. Yeah. Like I said, as much as I don't like Baldwin, yeah, that was a fair argument by his attorney to say, like, listen, we're representing our fucking guy. That's what we do. You rep the set. Now this part here, this is a little tampon ringing, I think. All of them were laughing at Baldwin's expense. They literally wrote "lol" at the idea of prosecuting Baldwin that could help her get elected. Oh my gosh, they're just mean girls, chat. Just mean girls. The state made sure in every possible way that the grand jurors were unable to fulfill their duties. They botched the investigations. They destroyed the gun at issue. Well, yeah. They conducted an improper press campaign to destroy Baldwin and take the grand jury. They violated secrecy rules even when the court said don't. They ignored the alert letter. They didn't tell the jury about the alert letter, really what it does. They kept the exculpatory and highly favorable witnesses from the grand jury. I mean, they keep rehashing this, but they're rehammering the points. And they're rehammering these points saying, look, even under this context, it's still bullshit. There's improper testimony that contradicts the things at Hannah's trial. And then, yes, under these circumstances, it must be dismissed. And that's it, guys. They're saying this has been fucked up too many ways from Sunday. They keep destroying it. They keep ruining it. And something has to go. And yeah, if this happens again, that's it. I think Alec Baldwin's got a hell of an argument. I'd love to see what Carrie Morrissey says. And certainly, could she be like, yeah, these guys are making it all up? Maybe. But what are they making up? I'd be very curious to see what they're making up. And what she's going to accuse them of making up. Because I'm not entirely sure. So that's kind of more of what we were looking at there. Hold on here, what am I looking at? All right. So yeah, that's guys. And Debbie says for $5 more, thank you for the explanation. You're very welcome. I mean, what are you guys thinking here? This is not a. Yeah, Seth Felter. Yeah, Carrie's gonna come back and say this is all bullshit. That's fine, but I can't imagine this is all bullshit. Bowles was kind of a hack attorney. He wasn't very good. And I'm not saying Baldwin just got good attorneys because he hired a big fancy law firm, but these guys aren't fucking slouches. I mean, like, the firms they're at, if you tried to act like Bowles and do what you did, you wouldn't last long because they'd be like, oh my God, you fucking suck. You fucked our client over. You're out. So I don't, yeah. I don't think these guys are completely making it up. Because if they did, they're fucked. Ag is saying, wouldn't Hannah's conviction go against Baldwin here too? In a way, I think it could, but it could also be used as an example of like, look, you already got a scalp. Now, do I think it's... I still think today there's a problem for Alec Baldwin. This idea of like, you can... Because remember, it's not like Alec Baldwin was playing with a fake gun. Or a prop gun. Or a gun like this, which isn't real. I mean, it's made out of plastic and it's red. It's a safety gun. He had a real gun. Alec Baldwin wanted the hero props, the legit thing, which I can't do because YouTube will kill me. But he took one of those and he went like this and pointed it at Halyna Hutchins. Also, by the way, check, give me all your money. And he cocked it back and pulled the trigger. That's a big, big issue here. Now, I know there's parts of this where I don't think it's explicitly come out, but we notice we don't. I was surprised because people are saying, like, well, Halyna told Alec to point it right at me. Halyna told Alec, point the gun at me. Notice who never said anything about that. David Hall, Joel Souza, or Ross Adiago. The three guys that were in that room, along with Halyna and Alec and Jensen Ackles. None of those people have said that. So, while I think there's a lot here, there's a lot of problems for Alec still out there. And as far as this conviction, I bet there's people are concerned she could use this, or he could use this to hide behind, say he already got a bad guy. I don't think that's gonna happen like that. So I don't think that's gonna work out that way. Funny bits, some chick on Twitch was live streaming Fortnite from her green panties. Oh. She was live streaming it on her green panties, like playing it as like a green screen? Huh. Funny. Someone put Fortnite on my body. Funny.
Yeah, she was playing Fortnite on her butt.
Oh, well, good for her. Nova says the trigger man. Yep. He walks up to Halyna, bam, and goes like this, and walks away. Drops the gun like in Goodfellas, or like in Godfather. Island saying 3 more months to this trial. Yep. James says it's grandstanding. Maybe. We'll see. Darcy says, do I stream on Twitter? Yes. Yeah, I do stream on Twitter. I think right now, got 109 people watching over on Twitter. So, hi out there, Twitter. Twitter peoples. I don't know. I didn't realize that many people like doing it, but a lot of people do. I don't know if they're on there just, oh my God, this guy's fucking horrible or what, but they are out there. You deal with it. It's an option for people to watch and for people to hang out. So, Soul Souffle saying, are the Baldwins defeating Morrissey before they even get to the courtroom? They might. I don't know for sure. This is a very, very strong motion. Doesn't mean it's guaranteed, but yeah, they're calling their shot now. They are calling their shot now, and they're looking to go after everybody. And I don't blame them. This is a shot worth taking. C. Shinny saying, can anyone get the grand jury transcripts? They will. You won't. Those are not going to be released to the public. But it sounds like they've already got, based on what they've cited in here, they already have some grand jury transcripts they've had access to. So you will never get access to them. You can't go get them, but they can get them. Typically, it's not easy to get. Like in Ohio, it's not easy to get a hold of them. Some states is going to be easier than others. Speak Life is saying, is a grand jury selected the same way a regular jury is selected? No. So the way a grand jury is selected, you bring in a bunch of people, and the judge is going to ask a bunch of basic questions, and the prosecutor's there, and he asks some questions too, like how are you doing? Do you know any of these people? I'm going to read off a bunch of names. Do you know anybody on this list? And then you go through people and you strike out a bunch. For Ohio, for example, a grand jury is 9 people. You only need 9. And then you might pick an alternate or 2 who can sit there. But generally you pick people who can stick around all day. Like I said, some counties, some places the grand jury meets every day, and your term as a grand jury person is like every Monday for the next, 2-3 months. Some places it's your grand jury is, and then there's a grand jury that comes in every Tuesday for the next 2-3 months, 4, 5, 6 months. I don't know, however long. Then there's going to be another grand jury that comes in the next day on a Wednesday. And then every once in a while, you might have an extended thing where, hey, this grand jury is going to have to hear this case and it's going to take us a long time to present it. Or they might do it over the course of over the course of weeks. And then there's some places, like that are very rural, the grand jury meets one day a month and that's it. It just depends on how big your city is. But choosing it, generally, it's the same everywhere. It's not as intense of a voir dire. It's a very, very basic one to make sure you don't know people. So. Noel says, I want to see the actual transcripts instead of the hide-and-seek games. Yeah, I wish they would block quote it better. Ag says, Jensen Ackles was super pissed after Alec after the incident. Well, I'm betting they were. I'm betting he was, because ultimately, if he had been standing where he was supposed to be when he's doing the, all rust, you're under arrest. I work for the Mako company. We're here to use sandpaper you down and paint you over. I don't like rust. That lines or whatever that cringe shit they were saying. When Alec sitting there going like he's supposed to go, well, pow. If he had been standing where he was supposed to have been when Alec Baldwin had shot, it would have killed him probably, or at least shot him. Pepsi Man should send. Well, C. Chinny says, so grand juries sit for multiple cases. Yeah, even in very rural areas, it's like you do more than one case in a day. I mean, for example, the one county I worked in, we would do the grand jury once, it was done once a month. But in that month, you got in like 10, 15 cases. I mean, it doesn't take much to present a case to the grand jury. You generally bring in the cop who was involved in it, maybe the witness or the victim, and you talk about the case. And is that enough to get the, he broke into my house, some guy robbed me, and we caught him later. And yeah, and Old Line Red saying my county does that. We sit for 4 months, 1 day a week. Yeah. And then sometimes it's just once a month. Green Cap's saying, why do grand juries in Ohio have to visit the jail, or is that just ones involving with that type of issue? No, there's like jail inspection. That's and I think hold on here. They have to do sometimes they have to do a report. I'm gonna bring it up. So, and grand juries have all kinds of weird roles depending on your state. Like here in Ohio, once every 3 months, the grand jurors have to visit the county jail, examine its condition, and they're, like, what are you feeding them? What's on their trays? Now, you don't have to sit there and taste test it, because most of that shit is nasty, and slop on a shingle. But, yeah, they have to check it. And if it's a, grand jurors, they check it, and there's a report that's done, and, they report on the matters to the county. They make a county report for that, and the report is then circulated on, and you can actually access those reports. That's something the grand jury does. You get to know about. But yes, that's an actual thing. Some places like we have to do here in Ohio. That's kind of fun, Green Cats. Why you're bringing that up? If you're checking on that, other places might have you do that too. Grand juries have all kinds of weird things they get to do from place to place. That's a shame, says, I'm jealous. We don't do grand juries at all. Well, as I said before, in Ohio, you cannot be indicted without a grand jury. You cannot face felony charges unless you're indicted. You have that right under our state constitution, meaning if the prosecutor tried to serve you an information, you could literally fucking laugh at them. You can't be prosecuted via an information unless you sign a waiver agreeing to it. The court you cannot be prosecuted via information. It's only by indictment. And that's kind of the cool thing. So like Kyle Rittenhouse, if that happened in Ohio and the grand jury wouldn't indict him, then he doesn't get indicted. He doesn't face charges. A lot of these cases where the prosecutor does an information, that wouldn't happen here in Ohio. That's literally legally impossible. Speak Life says a grand jury might only be a few minutes. Yeah, I mean, think about it. Like, let's say it's somebody stole your checkbook and they got caught at the bank. You know, you come in, say, yeah, I was at home and I had the checkbook sitting in the car and I came back out and the checkbook was missing. And then I got a call later that day said somebody was trying to write checks. Okay, well then you bring in the cops saying, yeah, I got a call, somebody reported their checks being missing. And then they called and said, the credit union down the street, somebody was trying to cash the checks. So I went down to the credit union and the person was already gone, but we looked at the video. And from my experience, that's Bob the heroin addict. I recognize him because I've arrested him a bunch of times before. You could do that in like 5-10 minutes. And then you tell the jury, look, the grand jury, here's what we're asking. We need you to determine whether or not they committed theft, whether or not they committed forgery. And you go, blah, 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 read off the statute. And in the meantime, either the recording's going or there's a court reporter there sitting away, typing away. And at that point, you shut off the recording or the court reporter stops. Everybody leaves the room but the grand jurors. They vote. And the way it works, at least where I've been at, everybody goes and stands outside the room. The grand jurors do their thing. And sometimes you wait a couple minutes. Sometimes it's like you leave the room and it's like a minute and they come knock on the door and, you hear like the foreman comes and opens the door like, hey, we're done. And they said, yeah, we agree that he should be indicted. And everybody, the foreman signs the bill. And yeah, there's a bill, or we'll say, hey, we're not going to bill him. Sometimes there's a couple of minutes. And they make their decision. It's not a super. I mean, it's a very elaborate process, but ultimately they go and discuss shit, and then they tell you what they're going to do. And if they say no, Bill, I mean, that's it. There's nothing you can do about that. So, Shitty says, what type of law do you practice? I'm a general practitioner at the end of the day. Whatever comes in the door, I mean, short of, like, I can practice anything in the state of Ohio. I mean, the only thing I wouldn't practice is, like, copyright and patent law, but that's because you need to be, like, part of the copyright patent bar for that. But yeah, I focus on criminal defense. I like doing criminal defense work, but, you come to me and say, like, hey, I want to buy some land. Can you help me put a deed together? Sure. I want to do a will. Sure. I want to get divorced, or can you help me fight for my kids? Like, yeah, sure. Those are not the funnest ones, but yeah, sure. Do it all. We do it all. So I do it all. Anyone that sits on the grand jury in Orleans Parish is required for 6 months. And in Ohio, it's a 6-month term as well. But like I said, if you're only meeting so many times, like, they can't force you to sit there every day, all day long. Like, in Cleveland, the grand jury meets every day. But it's different grand juries. Like, you couldn't expect to be sitting there all day long for 6 months. That's insane. But like out in the rural counties, you meet once a month for 6 months. Okay. Or some place you might meet once a week for 6 months. But you meet like in the afternoons or the evenings, like all kinds of stuff. Null says, do I practice federally? Not yet. I'm working on doing that. I'd like to start doing that coming up and getting admitted to the federal bar here in the Northern District. So that's something I'd like to do. And it's hard getting, initially making a name for yourself in the federal thing. So I'd probably take some appointed stuff at the federal level just so I could get my feet in the door. But I'm hopefully try to do that within the next, couple of months, maybe this summer. So, actually, they give you $50 a day. Also, Orleans Parish is New Orleans. Yeah, okay. Yeah, it's the county city there. Yeah, I guess I'm not good enough to specialty. Well, I'd love to have a specialty, but it's hard to get to the point where you have a specialty by yourself. That takes a lot of time and a lot of work on that, but you can do it at times. Like, I'd say, like Larry, the DUI guy, that's his specialty, but it's hard to get a specialty like that. You can get yourself in a market that way, but it can be done. It can be done. Let's see here. What else we got? Any other... Did I miss anything? Thomas, you're saying this worse than Binger? Yeah, 100. This is a lot worse than Binger. They were just unscrupulous. This, if she did this, she intentionally fucking lied and jerked the system around. She's 100% worse than Binger. Carrie Morrissey's a fucking defense attorney at the end of the day. That's like she got picked to be a special prosecutor. She's a fucking defense attorney. And then she goes out and does this shit? So she defends people and knows you're supposed to get all these things, and then she fucks with it anyway. That makes her even worse. Like, she should know better. You know, this is not like, that's the really tragic part of it. That's the part I'm really upset about. If this really happened this way. Of all the fucking people, she should know fucking better. So. Any thoughts on Crowder's amicus brief filed with the Supreme Court in Murphy v. Missouri? Which one's Murphy? I don't know him by the name. I know him by like the topic. Mr. Sniper says, how are judges done in Ohio? They're elected. Unless somebody quits and there's a vacancy in a position, then the judge will appoint them to serve the rest of the term. But otherwise, yes, you're elected to be judge. You don't get appointed to be judge. All courts are that way. The only thing it probably wouldn't be is a mayor's court because they appoint a magistrate. But you know, if you want to be the judge of wherever or the Supreme Court justice in Ohio, you have to get elected. So. When's Michelle Troconis' sentencing? It's May. Michelle Troconis' sentencing is they're setting it for May 31st, and that's actually probably a good idea because the judge initially, when she got convicted, he's like, "How about we set it for the 24th?" That's the date Jennifer Doulos died, so it's like. Everybody was like, can we pick a better day than that? Even the prosecutor's like, no. We're not doing that. So. It used to be Missouri v. Biden. Yes, I did not see it. Yeah, Monday is the Missouri v. Biden oral hearing. Yeah, and I'm looking forward to listening to that one. That one will be very interesting. So, yeah. Oh, Murphy v. Missouri. Oh, because it's Murphy is the fucking Surgeon General guy, isn't it? Vivek Murthy. Yeah. Yeah. If you guys would have said the Missouri v. Biden thing on it, I would have caught on right away. Yeah, that will be an interesting one to hear. And then, can I take Steve Dettelbach back, the head of the ATF? No, sorry, it's your problem now. I don't want him back. Keep him out of my state. So. Yeah, guys, that's it. We are all... Crowder apparently has a lawyer who will be presenting the amicus brief on Thursday. Well, good for him. It's got what, like Bill Richmond? It's gotta be nice. You can just burn money to have a fucking thing filed. So, John Thompson saying in Franklin County, Ohio, you sit for 2 weeks. Oh, interesting. Good to see you, buddy. Good to see you. Let's see here. Yeah, it looks like we're all caught up. I caught up on all the super chats. Yeah, so I think we're all set, guys. I think we all got caught up. Well, it's not Bill Richmond. I don't think he's admitted to the Supreme Court bar or whatever you need to do it. Guys, I've said it before. To get to the Supreme Court bar, it's not fucking hard. When people like, oh, I'm admitted to the Supreme Court bar. It means you paid money and 2 other people who are part of the Supreme Court bar sponsored you. And you wrote their name down on the thing and they signed off saying, yeah, you're a good person. Like, literally, you pay to join. It's kind of like that. You know that attorneys of distinction thing I was making jokes about for a while on Locals? Or you see somebody's like, I'm a super lawyer. Yeah, you pay them like $500 and they give you all these awards and stuff you could put on your wall. So when people are like a super lawyer, a lawyer with distinctions, like those are paid awards. And getting Supreme Court, like to get into federal courts, you just pay for it. That's really all it is. It's a money making thing. You don't have to do anything to get on the Supreme Court thing. It just exist as an attorney. So, SCOTUS bar. Who do you have to suck? No, I mean it's easy. The Supreme Court bar. I'm serious. The Supreme Court bar admission. Here are the rules for the Supreme Court of the United States. I mentioned them before. Let me see. Oh crap! I already had it. Where'd it go? Yeah, here we go. Here, these are the rules to get into the bar. The Supreme Court. Do I want it as a gift? Do I want this as a gift? Well, I don't know how you guys could do it. Even if you guys crowdfunded that, that's not. But it's just like when people say they're super lawyers or anything like that. This stuff is not. Anybody's like, I'm a super lawyer. It's like, yay. It's like, how much did that one cost you? So, just saying. I'm just saying. So, here's how it works. Here are the rules. They're not hard. They're pretty easy. You must not have had any adverse disciplinary action during the previous 3 years. And you must appear to be of good moral and professional character. You must have 2 sponsors and a movement. The sponsors must be the bar of this court who know you personally and are not related to you by blood or marriage. One of the sponsors may also move your admission. Alternatively, in the movement may be another member of the bar of this court and may be a relative. Please indicate the name you want shown on the certificate, which may or may not include a middle suffix. Those are the rules, guys. These are the rules. That's it. In the past 3 years, you haven't had any discipline issues. And then you have to find 2 people who aren't related to you to say you're okay. That's literally all it takes. That's all it takes. And then how much is it? How much does it cost? Okay, yeah, and an admission fee of $200 must be submitted along with the application. Yeah, if you're elected to be admitted in open court, do not complete the motion for admission selection. You submit the application, certificate of good standing, and you will receive a package that includes a calendar showing available dates for admission and argument sessions. You pay $200 on the day of your admission. So you can be admitted in open court or you can be admitted on a written motion. And you get a written motion that they send you back. And you can, here's your Supreme Court bar thing, but you also can get a written motion. And you can be like, look, the Supreme Court talked about me. Yay! So, I thought it would cost more. Well, I mean, they're not going to do that to you. So, he'd be a super mayor. No, you gotta start stealing from people for that. So, Ghazi's not a super lawyer? No, because why would he? That's generally for private guys, not for government lawyers. Brad says, Sean, we think you're a super lawyer. Hi, aw. Aw. Thank you. Oh, brackets out, jeez. Ariel says, dang it, YouTube didn't show you live for me. Well, sorry about that. Sky Tweet says, you are okay. Well, thank you. You'll sponsor me. That's great, yeah. Be great. You show up in court, but like, I move that he become an attorney. You let him practice here. They're like, who are you? I make rape seeds. I make it so you could drink jeans as booze. Yes, pay $200 to join the elite party. Yes. So, I'm a super duper lawyer. Aww. But yeah, that money could go to an NFA item. Yes, that's the funny part. So, it's a super lawyer that abuses Clyde. Yeah. So, that's all it takes. That's all it takes, guys. It's nothing. There's nothing. I'm just. When people are like, I'm admitted to practice in like the Sixth Circuit and the Fifth Circuit. Like, yeah, you paid the $200 to get admitted because you were already there. Like, wait, some law schools do that for their bar passers. The school would literally sponsor a trip. Dayton's law school does that? Like, fuck. They literally sponsor a trip and you get that. That's so. Well, I guess for the amount of money they're fucking ripping you off on, I guess that only makes sense. So, I am your law daddy. I don't want to be your law daddy. That's not. That channels too much of the bad stuff out there. So, I don't want that. That's straying too close to the sun because eventually you go from calling me law daddy to law daddy, and I'm like, I don't want to hear that. I don't want to hear that. Apparently 2.0 is saying Twitch is actually amazing on its notifications. I don't ever go in the app, but I immediately get notified if Sean goes live. Highly recommend. YouTube and locals always notify late, if ever. When that's the funny thing. I try to use locals and they don't tell nobody. Oh, look, and there's Clyde. He's such a good boy. Will I sue the Guardians to bring back Chief Wahoo? No, but maybe I'll sue to make sure that those Indians that whine and cry out in front of the baseball stadium go away. It's like, we did what you wanted, now leave us alone. So. Oh. All right, guys. Well, we've had a busy day today, fun day today. Locals really shits the bed all the time. Yeah, I don't know what. I've tried to reach out to them, ask them what the fuck's going on, but they're not always good about it. So I don't know. 406 people here, guys. Thank you so much for being here. I appreciate that. Well, 400. As soon as I say something, it goes down like 405, and it's like, so. That is it, really. Yeah. Yeah, that's it. So, I am probably gonna call it a night. Get ready for the week. It's gonna be a fun week. It's gonna be an interesting week. There's gonna be stuff coming out. The Delphi murders, the court hearing, whether or not what the judge is going to do to sanction those guys. We're going to find out what happens there. I really hope nothing bad happens, but I'm kind of getting bad vibes that something will happen just because the judge down there is a complete asshole. So that's going to happen. How about the Washington Commanders? I don't, my dad would love me for that, but no, I'm not going to fuck Washington Redskins. Ain't the Browns. I don't care. So, my black work cutting out for him with gay black men fawning over me. Jeez. Don't scare me like that. So, that is it for tonight, guys. Thanks for being here. Tomorrow night we will be on Locals. We'll be at Locals. That's at potentiallycriminal.locals.com. You do 1 month free, Criminals 2024. We'll be on at 8:30, kind of hanging out, talking. And tomorrow we're going to try to catch up on Daniel Howard Day 9 because he got caught fleeing the state of Idaho and is stuck in a jail in Washington. So they're probably not going to have the trial tomorrow because he's indisposed.
And then, guys, remember every Thursday night at 9:30 we have the Thursday night crime stream. That's every Thursday night at 9:30. So next Thursday we will be having it again, as always. And I hope to see you guys there if you're new. So thank you again, everybody. And yeah, I think it's very appropriate for tonight. You know, just because you did it doesn't mean you're guilty. And I think Alec Baldwin's got a hell of an argument here. I think he's going to be not guilty. I think he gets to walk. I think he's probably going to have to walk. I mean, this is not good. This is not a good look for the state. So, yep. So, anyways, guys, that's it. Take care. Good night, everybody.